goodness, when the vast powers that I hold to make Tyler and Ann voting members this evening, pull them up from, I should not use the term the minor leagues, but make them voting members this evening. And so unless there's any objection from other board members? Seeing none, thank you. Amendment, oh, we had the quorum with 5 folks. Amendments to the agenda, any? Seeing none, we'll move on to acceptance of the minutes of prior meetings, July 13th being the prior meeting.
I would move that we accept them as presented and would like to compliment George on the detail of these minutes.
Can I make a note? Yes, awesome job on the notes. But I did have one quick edit potential. So the last bullet on the last page, talking about new business, it lists out the potential peer reviews. We talk about engineered plans, including a traffic safety review, wetlands delineation, and potential forestry violations. We had discussed wetlands delineation or wetland delineation / permitting, like wetland resource permitting as well. So
Right.
just wanted to clear.
George, you got all of that?
Yep.
Those good things. So I've got a motion, if we had a second,
Sure. After that, yeah.
As
Second.
amended.
As amended.
As amended.
as amended. And then all in favor, raise your right hand, left, whichever. The minutes are approved.
I'm abstaining from that vote, so I was not here.
So informational exchange. George, anything from town officials?
Not beyond what's in the agenda packet.
Okay. I guess the one thing is the budget committee met the other day, and it sort of impacts this group is they're recommending approval for $16,000 for a GIS system to do tax mapping, which will have a lot of good tax map information, and that's separate from what George has done for us in the past. So
Making sure that everybody is aware that that is an article that is being presented at the town
Absolutely.
meeting on the 16th.
can I put in a plug for the IT stuff as well?
You're the
Since we're on
chair.
television. There's the other 3 articles are also improve the phone and internet system in here and buy some new computers and then heating and HVAC for that. So if you're available on the 16th or your friends are, please come out and vote. So town officials, residents, any comments from residents? Seeing none, any comments from non-residents? Seeing none, we're on to continuing business, which is the substantive review of the preliminary plan application for the proposed 13-lot cluster subdivision, Hallowell Road map, also known as Deer Creek Crossing. And before we start that, I need to ask Tyler, we may vote on something this afternoon, so I asked Tyler and Ann, since you're now members, have you had a chance to look at the notes, the minutes, the film from the last meeting, and are you comfortable if we ask you to vote on it this evening?
I did read the notes, so I did not watch the video, but
Okay.
I think I'm feeling comfortable. It doesn't sounds like there was a lot of public comment, but nothing that seemed surprising.
Okay,
I would abstain from the vote because I missed both the site walk. I have kept up on the minutes, but I missed the site walk as well.
Okay.
So I would abstain from this vote.
then I would ask the other board members, are you comfortable with letting Tyler vote, given
Yes,
the
I,
information he has?
yes.
Okay, then Tyler, you will have an opportunity to vote on this particular one. So we covered on that, who can vote? And with that, I think we will turn it over to, are the applicants here and ready to go? Okay. And then I will turn it over to our town planner to kind of go over, George went through a lot of stuff, and you probably have seen it. He put notes together, did a good job on the public comment. Well, that's part of the minutes, but he put information together on concerns that were raised in the public hearing or his review of the plans, going through the preliminary plan checklist and other input. And so, Mr. Thabarge, I will ask you to go ahead and provide or start the discussion.
Thank you, John. The agenda notes that I prepared kind of summarize where we are in the review process. So at the last meeting on July 13th, you determined that the application was complete, and under the ordinance, you are now have, from that point, have 60 days to make a decision, which would be then by the next meeting. I did include a summary of the public input that was taken during the public hearing. The issues that were raised included survey accuracy, the drainage concerns, timber harvesting violations were noted. Disclosure of all potential encumbrances was an issue that the board had discussed, and that also came up during the public comment. The accuracy of the wetland delineation, again, was raised. The location of the stormwater basin, that was raised by the Conservation Commission in addition to the wetland issue, and the existing and proposed stream crossing. The Conservation Commission, in its written comments, requested a high-intensity soil survey, and during the public hearing, they did support the creation of the open space network and connectivity with the Timber Oaks open space. Subsequent to the public hearing, I received an email that was also forwarded to the board that addressed concerns about impacts on the schools, impacts on the Aquifer district that extends partly onto this property, and also concern for continuing zoning violations on the property. You started your substantive review last time, and you'll continue that tonight. With the completion determination, I sent notice as required to the school superintendent, the road commissioner, and the fire chief. Got written comments back from the road commissioner, which I included in your packet, and written comments from the school superintendent, which I forwarded to you. So at this point, the board, under Maine law and the town's subdivision regulations, must within the 60 days make a decision either to approve the application for preliminary approval without any conditions, if you think it meets all of the standards. Secondly, your second option is to approve it with conditions, and part of those conditions are intended to say you think that the application can meet a standard or an impact can be mitigated with an approval condition. So and that would apply to any and all issues where you feel that it could pass the standards if it has certain things done. Then the third option, if you think going down through the standards that any one of those standards this applicant has just failed to meet their burden of proof, then you can make the third option of deciding to deny the application. In all cases, the burden of proof is on the applicant to demonstrate compliance. I've drafted some preliminary approval conditions that are intended to give the board an efficient way of going through the standards and considering possible mitigation of any that you think need to be mitigated through conditions of approval. But these also address all of the public comment areas that were submitted. And then, in the event that you determine to go forward with the project, these will also provide a basis for drafting findings of fact. So what I tried to do is give you a document that will help you efficiently process it and cover several different aspects of the review process and documentation in one mechanism. As we go through those, I've ordered them in the order of the standards within the ordinance. John, in reviewing it, noted that some of them directly respond to what has been discussed by the planning board. It came from public input. Others weren't really brought up, but they address certain standards and criteria. So I did prepare another draft of those conditions of approval that segregate out the ones that address issues that came up in the substantive review and ones that haven't been discussed yet, if that would be helpful, if you'd rather see it in that format. So I won't, till you get to that point, I won't distribute those, but I do have those.
And the items are the same, it's just in a different order, if I'm not mistaken.
Yeah.
Kurt.
So as you walk down through the draft agendas, if you agree to that process, then what you do is take each one references standards that are, a standard that is in the ordinance, and you can decide whether you think that the application as submitted meets the reference standard, and then you wouldn't need a condition of approval, or you think that the condition of approval is necessary and would like to see it applied, or you think even with a condition of approval, it can't meet the standard. Then you would say that is a basis on which we would deny the project. So as we go down through the part for the substantive issues, or that were raised during the review process, then we can kind of each one of those indicate whether you think it passes without a condition, whether the condition is necessary and satisfies the burden to give an approval, or whether you just think there's no way that it meets that and you would not approve it on that basis. In each case, I recommend and have been advised by attorneys that it's a good thing to, if you're going to apply a condition of approval, check with the applicant to see whether they accept that condition of approval. Because if they agree to it, then that won't be contested in the future as likely. In each case, the board majority should vote on whether to approve, to apply a condition of approval, or to deny. So each individual item should get a majority vote, as opposed to going through them all and then giving a majority vote. Some members may want some not others. So that gives you a consistent result. If you decide to go forward tonight with a condition or preliminary approval with a set of conditions, then basically the applicant can move forward with the final plan application process. They need to go to some state agencies. They need to get cost estimates, bank financing, performance guarantees. And so you could give a preliminary approval tonight if you're satisfied that they meet the burden. If you decide on one or more standards that they don't meet it and you're leaning toward denying, what I would do is propose that I would prepare findings of fact for the next meeting in preparation for a vote to deny the application, if you move in that direction. So if you approve it tonight, I think we can use the existing, we don't need to do formal findings of fact because it'll be coming back to you. If you decide to deny it, then we would want to do that, but we should have time to prepare it for the next meeting, so we can do that efficiently.
And George, just maybe a point of clarification, with the big if we are not satisfied, if there are too many things or
Yep.
a couple of big things
Yep.
that are still not there, a fourth option is in lieu of denying, and I'm
Yep.
not saying we're gonna do that, is
Yep.
to ask, because we're under the time crunch, to ask the applicant if they want to try to fix it or correct those.
Yes, you have to make a decision within 60 days unless the applicant agrees to an extension. And if you're at the point of deciding to deny the application because it fails to meet certain standards, you can ask the applicant, if they're given more time, do they think they can come up with a burden of proof that will satisfy the board? And if so, how much time do they want to go through that exercise? And then finally, I would point out that I had contacted the town attorney back in May to get clarification on the issue of public hearing versus public comment. And the town attorney has advised that if you take public comment on an application, either for conditional use or for a subdivision, it should only be done in a properly notified public hearing. So it's really important and following the bylaws that give parties the opportunity for rebutting evidence that's submitted. He feels that that's very important in terms of defending any decision that you make. So you should not take public comment on a subdivision application unless you have a scheduled public hearing. So I think that's just important to keep in mind. And I did receive also clarification from the town attorney. I did seek his guidance on the issue of the summary judgment, which had been raised. You do have in the record now a lien discharge. The property owner paid a fine. The town select board accepted that fine, and determined that the violations had been abated to the point that the select board was satisfied and was ceasing enforcement action. According to Jack Conway, the town attorney, no formal summary judgment of the court has been done. However,
It's not summary judgment, it's a satisfaction of judgment.
satisfaction of judgment,
Yeah.
whatever the proper term is. That has not been done, but he's prepared to do it if the town requests it. So that's where that legal issue stands. And with that, I think I've
Before we go off,
covered everything.
we've done this like 3 or 4 months in a row. Are we the ones who asked the town then to do that? I mean, go through the town manager,
Well,
town,
again, the burden of proof is on the applicant.
so they're the ones to
They
act.
have to prove that they have, there are no encumbrances that would affect their ability to sell lots in this subdivision. So you can ask them if they want to do something about this. Otherwise, it's really the board's judgment whether to move forward or not.
Okay.
You don't have the responsibility to get that documentation.
Okay,
I'm good.
I'm good. And maybe next month we won't talk about it.
Okay.
Can I ask just a question? Did we get a comment back from the fire department?
There have been some emails during the discussions, and, but there's never been a categorical statement of what, and the applicant has offered different options, but has not really settled on any at this point. So the fire chief hasn't really been asked to review a formal proposal for fire protection at this point.
Okay. Until the applicant gives their proposal. Okay.
Any other questions for town planner? Seeing none, do you want to go ahead and start the,
It's up, if the board wants to procedurally go through and review if you're ready, if there are other issues that you need to discuss, and we can discuss those issues as we go through the draft preliminary approval conditions. So if you're prepared to do that, and then the question is, do you want to use what was in your packet, which you may have prepared by, or do you want an alternative organizing of those draft conditions of approval where 14 respond to issues that came up during the review process or the public comments, and the other 11, or excuse me, the other 11 are just other issues that are addressed in the ordinance. So whatever you prefer, I'm happy to do.
Is that not in the packet?
It's not in the packet, but I have
See a
copies
copy
that I
of
can
that?
give to you.
yeah, not in that, they're in there, just not in the order.
Not in,
Yeah,
they're
I
all
get it.
in there, just not in the same order. So I'll pass those around.
What do you guys
to
think about just having a quick discussion between prelim and final?
Yep,
What do you think about-
procedurally.
Yeah, procedurally.
Sure.
What we're doing here. Is that okay? And George, if we do
Yes,
that?
absolutely.
Thank you. No,
Did you have a question, or just what I have?
no, just like the difference here, like what we
Okay,
are
so the preliminary
moving
approval again
versus-
is set up, and this follows a state model, and it works quite well in terms of giving the applicant a clear green light to go forward and continuing investing in the project, because as they go forward, the costs of doing the plans, the soft costs of this development keep rising. And so this is an interim step to say to the applicant, we have reviewed your application on a preliminary basis, and we've determined that it can meet all of the standards, or if it can't, in your opinion, there's no point in spending more money and going through more time and expense to prepare a final plan that isn't gonna get approved. So the interim preliminary approval gets the board to commit to say, we think this application can meet it if all of these legal and technical issues are addressed, including peer reviews of some of the information that's been submitted. Again, if you're not convinced that this, even with a peer review, for some reason, there's some, in your mind, there's some standard they just cannot meet. So let's just take one as example, the fire pond, okay, or water supply for fire protection. The current application has indicated what they are willing to do to address the standard for water source on site is a fire pond with 36,000 gallons. The standard in the ordinance is 120,000 gallons, unless the fire chief approves that with a combination of sprinklers. The applicant has said they're willing to do 36,000 gallons if the fire chief will not require. So in my mind, that doesn't meet the ordinance standard. So that would be an example of if that issue is not resolved to your satisfaction that it meets the standard of the ordinance, there's no point in applying to MDOT and DEP and Maine Historic Preservation Commission, no point in going to the bank, no point in hiring or paying the engineer to do detailed cost estimates of all the improvements. All of that work, if this project is going to be denied because they do not meet the fire protection standard or any other standard, then there's no point in giving a preliminary approval and you should deny the application. Does that help clarify?
Yes,
Okay.
yes, it does, thank you.
Okay, then my thought is, the town planner's done a lot of good work with that. We can start with that, we can go through the checklist quickly and see if there's something on the checklist that, I mean, many of the things he's just put on his paperwork covers it, or we can go through his work first and then get to the checklist, just make sure we don't miss something on the checklist that he didn't cover.
My recommendation would be to start with the conditions of approval because they address the substantive issues that have been discussed.
If that's
And the
o-
public comment that
The
came
ones that
in.
you drafted?
Yeah.
Yeah.
And then, like you say, then we can just take a quick look at the checklist to see if we've missed anything.
Yeah, what checklist are you referring to?
The application included a preliminary plan
Oh, okay.
checklist
Okay,
that
yeah.
goes down through every standard.
Yeah.
So for example, one of the standards is they have to have mapped all the farmland soils. And it's just a technical requirement, but if they didn't have it, that would fail to meet the standard.
Okay, then I have seen nobody shaking their head horizontally, so
Okay.
I think we'll
So
start with
if it's
that.
okay, and this is all new for all of us. So I hope everybody can work our way through it. So the first draft condition of approval is for, and this is right under section 6.6L1. If the board gives a preliminary approval, it should specify what changes they are going to require as a result of the preliminary approval process. And two that have been discussed, one is the standard in the ordinance that calls for extending a right-of-way for future road connections. We've discussed that. The applicant has indicated that they're willing to put one in off the end of the hammerhead to the abutting property. It doesn't show on any plan. So that would be an example of a condition of approval that would mitigate that, address the standard, and the board could tell the applicant, when you come back with the final plan, you want to see it on there. Secondly, during the public testimony, the Conservation Commission representatives suggested that the stormwater basin just above the stream on the road should be moved out of the Resource Protection District, which I think extends 100 feet from the stream. If you agree with that assessment, then and there's kind of two counter arguments. One is that, and it was made by the applicant's engineer, if you move the stormwater basin further away from the stream, it collects less of the road runoff, and then some of the road runoff goes into the stream without treatment. So it's, there's pros and cons to each location, and it's not clear how far the stormwater basin would have to move to get out of that. If it's a matter of a few feet, that's one thing. If the entire thing has to be moved, that's a different issue. But that would be an example of a change that you would require. And I don't know, we had also talked about lots 6 and 7, and I have a condition of approval for requiring a site plan for each of those two lots to ensure that there won't be impacts on the wetlands on those lots. You could say, we don't think those lots are suitable, and we want those removed from the plan. That would be an example of a change that you would require for the final plan. So I've identified two. If any of you have other changes that you would like to see in the plan, this would be the place, and now would be the time to suggest that.
And so this is very general. This is like culverts, this is roads, this is,
No, it should be specific at this point.
no, I mean, what we're talking about, changes to the plan.
Yes.
That can encompass
Yes, it
everything.
could.
Okay,
It could
so,
encompass a lot. So if there are specific changes that you want to see made, now is the time to indicate those, and those can be included as conditions of approval.
I think Calvin, I don't know if you guys saw his comment letter.
Yeah.
He made some good comments too.
And I guess maybe Julia, not to interrupt, but while you're looking for it, a lot of the nitty-gritty will come up in the final plans, if I'm not mistaken. So, and he has some good things that we ought to consider tonight. I think some of the, so I don't know if you had concrete on the plans, but he says
Yeah, I
should
think
be
John's making a
HDP.
distinction. Is this something that you think you couldn't approve this subdivision because it would fail to meet a standard, or you would like to see the Public Works comment, the road commissioner's comments, requests for, so for example, he said instead of having a 20-foot driveway culvert length, he would like to see a 30-foot driveway culvert length because people backing their trailers, they crush them. That's not a standard of our ordinance that you could deny the project on, but it's a request by the road commissioner to get a better result of the project. So you could, if you feel strongly that that is a make or break standard, you could put it in, all of the changes requested by the road commissioner. You could make that a condition of approval if you vote by majority to do that. Or as John, I think you're alluding to, when it comes back for the final plan, you could ask the applicant to incorporate those changes. And again, on all conditions of approval, you should see what the applicant is willing to do.
I think it'd be nice to have it at the preliminary stage versus, so that the final plan is in place and we're not making corrections between the preliminary and the final to that extent. If we're increasing the,
There's no specification for a culvert at this point.
but that would be a condition.
It could be.
Actually, that's a big condition, or not a big condition, I'm sorry, there needs to be a culvert there.
Well, they do specify 15-inch culvert diameter. I don't think that they specified the length of them.
I think you were saying one, which would, one culvert's 20 feet. Yeah, that's the length of a standard culvert.
And if we were to, let's just say we were at some point in time, as we're going through this, we were to say, okay, here's the road commissioner's comments. We go through them and just say, we would like to make his comments a condition.
You could make every one of those comments a
I mean,
condition.
I think we gotta go through to see if, you know,
Yep.
they're worth making. I mean, I think, not to pick on Calvin, they're probably all very good, but there are a couple in particular that, you know, lessons we learned from another subdivision.
So-
Exactly.
I can run you down through those,
Yeah, so there's another big one in here is the stream crossing.
which is addressed in the draft conditions of approval.
Before we do that,
Yep,
can we vote on these two,
Yes.
A and B?
sure.
And then we can get, some point in
If
time,
there are any
we'll
others.
get to,
Yep.
road commissioner's comments, and we'll just decide if all of them or some of them, but I need to keep it simple, George, for me, so if we just gotta vote on these two, and,
Simple is always good.
so, there's two comments from George here. Any comments from the members?
On those two?
Yep.
What about the pond outside of the resource protection?
Well, I think, yeah, go ahead.
Yeah, what do we think about that?
I kind of like to see more information, because I can see it from both ways. And I don't feel like I have enough information to say whether that should be a condition or it should be changed or
Right.
stay the same.
Yeah. Yeah, agreed. What do you guys think about that?
I'm good with, well, I guess the first question was, for the app, my thought would be, get Alan's comments, and see if they're willing to do it. My understanding is 1A, you've agreed to do that. That's the right-of-way extended to the end of the property.
Correct.
Okay, so that one we're set on.
I mean, you can ask for additional studies, right?
Yes, I was thinking the same thing. Real quick, where is the right-of-way going? Up?
Right straight off the end of the hammerhead to the property line.
Up here?
No, the other way.
Straight out, straight toward the property, yep.
There you go.
Right off toward the property line.
Okay, and so this is a wetland, right? This thing right here?
This would just be right away.
Right, okay.
So you won't build, they would not build anything there now, it would just be if the neighbors, the intent is to keep from having a whole bunch of dead ends and isolated.
But that right of way
no-
would cross a wetland.
Yeah.
And if you think that that's an issue that you shouldn't have a road, then you could say we're not gonna require it.
I mean, the idea of the right-of-way is a road in the future, right?
It's paper street.
Right. So,
To avoid landlocking,
yeah.
pretty much, is the.
So do we have to go that way? Can you go south or north? Like, I don't, like this.
Not given the property line.
Yeah, I think the
Timber
intent,
Oaks open space is to the south, or east, or whatever direction that is.
I don't know, maybe it's not that big of a deal, but it's a road crossing the land.
It looks like a pretty narrow drainage area.
Yeah. Is there a stream there?
I'm sorry? Oh, sure, I'm sorry. I've got extra copies for anyone who wants one.
shows, oh, sorry. Blocking it. Shows a stream setback, it doesn't necessarily show the stream.
Yeah, so there is a stream there. There's a stream, so that is the stream in the middle of that wetland,
Yeah.
right?
I'm good with doing it with the, I hate to say assumption, but, if it goes to actually be built, there would be a requirement to cross the stream correctly, cross, the wetlands correctly. They're not gonna be able to just do it, so, and I don't know who that would be on, that's a future issue, whether it's on the next property, next developer, next door, if they ever come along. So-
Or the town 50 years from now.
or the town 50 years from now, if they decide to connect it. I personally am a big believer in interconnectability of neighborhoods, rather than just chopping off little ones and little small, and not having the ability to get around the town.
What's on the other side of that?
There is vacant land, there's a narrow strip of land, and then there's some larger parcels beyond it.
Milky Way Lane comes into that one. Sorry.
It's quite a ways over.
Okay.
My agenda notes last time had a diagram that showed the future interconnectivity to go over to Dyer Road or back out to Hollowell Road.
Dyer? Davis?
Davis Road, excuse me.
My thought is, would we require the connectivity, since right now it's just green space, whatever you wanna call it, and then when they come to build that road, our successors or whomever will make sure it's built to the standard. They can't just come in and build a road. Whoever the next developer is would have to
Yep.
build it to the same standards they're building their crossings in this subdivision, or maybe even higher. Thoughts? So, does that take care of the right-of-way question? And then I think we're still on the question of moving the pond.
Are we voting on each issue, or are we voting on these things together?
I was just gonna do 6-1 together, but if they're two,
Nope,
if we think we're gonna come with two different, this one we know, so we'll vote on 6-1A. All in favor of requiring the right-of-way extend to that property line, please raise your hand. 4-1, if my math is correct, it passes.
No, I'm not voting on
Four-
Oh, that's right, I'm sorry.
401
4-0-1.
401.
Call it a draw.
You're gonna remind me every time.
That's
I'll be damned
okay.
if I remember. Okay, so then 6.1B is the location of the pond.
And just for the record, it's a stormwater detention basin, not a pond.
Excuse me, thank you.
Yep.
Stormwater detention basin.
On this item, I think I remember someone bringing it up, that it's our ordinance states that it's not allowed. Do we have that in the ordinance at all, that stormwater features are not allowed in resource
The
protection?
representative of the Conservation Commission who spoke indicated his opinion is that they should not be in the resource protection.
Okay,
I don't believe that it's prohibited by the ordinance.
okay. Thank you.
So we really don't have a ruling if are the indications that the chief would say that we're going to have 20,000 gallons.
That's a different issue. Yeah.
But no, I think Ann was going somewhere. You were talking about this one, when you said studies?
Yeah, I mean, I think the planning board has the ability to bring in their own expert.
Yes, and so I think this could fall under that, either the engineer or maybe the person looking at the permitting,
Move that to a peer review?
peer review question.
Okay.
You know, pros and cons to both.
Yep. So you would delete that then, for now, and put it down
What do you
into
guys think
peer
about
review?
that?
I agree with that.
Yeah.
I can see it both ways as
You said
buffering
that
the
too,
road
yeah.
and,
Well, they're gonna review it with the detention pond,
Mm-hmm.
where it is now, and then the guidance would be, is it better to move it, what happens if we move it outside of the, is that what we would ask for the peer
Yeah.
review?
And I don't think it's gonna be this big, you know, they're probably gonna say it really doesn't make much difference where you put it in terms of the stormwater capture.
Be my
So-
guess, but, okay, so, are you good with that, Mr. Applicant, that we would defer the decision to the peer review?
Yeah.
Okay, all in favor of deferring the decision to the peer review, whether it stays as designed or it moves, and we're not talking about a major redesign. I mean, we're not talking about,
It's probably
you know,
just
getting rid of 10 lots to put a pond in. That's not what, okay. All in favor? 4-0-1.
There you go.
Okay, the next one is the survey, and there were both board comments and public comments about concerns for the lack of accuracy of the survey. And for the record, it's my understanding and the
Is it,
applicant,
is it the engineer estimate, is the next one? Did we discuss it?
No, we're going by,
Oh,
Six
new
hundred.
list,
we switched to the new list.
the
Yep.
new list I asked for, thank you.
Yep. So I would point out for the record, and the applicant can correct me if I'm wrong, but they did not submit a new survey. They submitted a survey by the prior property owner. So that clearly would not pass muster for final plan approval. And that survey itself has noted discrepancies in the notes about certain areas are not clear title around the periphery. There's been testimony during the public hearing about concerns for survey accuracy. So the four issues that came up were marking the corners of the parcel per the ordinance, those areas of questionable title, and the potential impact of if they don't have clear title to certain areas, including it in their open space, may affect the calculations. And then finally, during the last meeting, I checked my notes again, and I saw that there was some question. It must have been during the title search, a CMP easement was identified that doesn't appear on the plan, so that would be a fourth issue. So section 6.7C3 addresses all of those issues, and the draft condition of approval says if they can get proper documentation on those issues, you think it could pass the standards for surveying and for open space. If you don't think that, then this would be one where you would say, we're not convinced, the applicants failed to meet the burden of proof, and we would vote to deny it on this end as well as other items. So do you accept that what surveying they've submitted is adequate? If you don't, will this draft condition of approval mitigate it to the point where you're satisfied that it can? Or do you just think that the survey is so erroneous or questionable that you couldn't be convinced that they meet the standards?
I mean, it is a requirement of the prelim plan, right? Number 3, under
Yep.
prelim plan. And it can't be waived.
No.
we don't want it to be waived. Because, I mean, I think this could play a big part in the proposed project, depending on what they find out there, right? Like, it could move stuff around, or you might need to move stuff around, right-of-ways, boundary markers, things like that, so, I'm on the fence on this one. It's a pretty big one.
I think it was majority of the controversy was that one point that the president of Timber Oaks was talking about, that one corner point that was off by, in his mind, 2-3 feet, whatever it was. But keeping in mind that it will all have to get resurveyed when, for final approval, because all the lots have to get staked out.
For the record,
Right.
have you identified yourself?
Oh, yeah, thank
You
you.
haven't been here before, right? You're sitting in
Yeah,
for Charlie?
Yeah,
Could you please, just for the
Yeah.
record, identify yourself so
Yeah.
that we have it in the minutes?
yeah, Max Dowdy.
Max Dowdy?
Yeah.
And you might as well do it while you're sitting there.
Yeah, and I'm Jack Dowdy.
Okay. Thank you, George, for reminding me.
I think the issue is that a standard boundary survey made by a certified professional land surveyor with everything that we require wasn't done and still hasn't been done specifically to include all of the things that George mentioned. So I think that's, even if it's off just a little bit, I mean, we're missing right-of-ways, potential easements, all of that. So I think that is the thing for me. So the question is, are we okay with that going forward for the final plan, or
Mhm.
do we want it for this prelim plan, right?
Any other thoughts?
Well, I think that if it's done at this stage, the preliminary plan, that it's gonna eliminate any questions when we get to the final. It'll be done.
If you go in that direction, then you either have to deny the project at the next meeting or ask the applicant to an extension, and how much time does he think it's gonna take to provide the accurate survey?
We could do that. It's an option.
That would
Do you-
mitigate all the risk.
Yeah. Do you have it in the works?
Yeah, I mean, we have it all lined up,
Okay.
ready to go. It's just pretty much to do whatever you guys need us to do. Yeah.
So you could, then that begs the question, could you, if we made it, can you have it by the next meeting, is what I'm trying to say.
Right. Yes.
You can have it by
Yeah.
the next meeting. So we could check that.
Yeah, we figured it was going to become a condition or something to that effect, right?
Okay.
The surveyor preferred to do it after prelim.
That's interesting.
Yeah,
Because he had the survey done and then he'd go stake all the lots.
Because usually they would just put a bunch of pins in the ground, and then for whatever reason it got denied. Now you have a bunch of pins in the ground.
Yeah, without being too much of a wise guy, I would prefer to still be driving my '75 Corvette, but, so, I mean, if this is a requirement, it's a requirement.
Yeah.
With my wife, it was a requirement to sell it, so, that's just my thought, that we'll see what everybody else says. I hear you, and we're not trying to
Right.
unnecessarily jack up costs,
Right.
so. Any other thoughts on,
Who's the surveyor? Is it the?
Jam.
Yeah.
so if I'm understanding you, you're saying you can have it done by the next meeting, September 7th?
Correct.
You may wanna come back to that one after
Okay.
we get through, and then we'll decide. You can
Okay,
decide.
we'll punt that one for a few
Yep.
minutes.
So the next one is the request of the Conservation Commission that a high-intensity soil survey be done. And generally, the ordinance indicates that that is a piece of study that the board can require, doesn't automatically require it. And the concern would be if you get into an area where the topography is such that you have extensive wetlands and they're weaving the lots in and out of the wetlands everywhere, and you're not sure exactly where the hydric soils, which often extend beyond the wetlands, start and stop, and that could affect house foundation drainage, it could affect the road integrity. then if it's an area where the soils are questionable over extensive parts of the project, then you would want to see a high-intensity soil survey. Generally, however, this particular property, based on the general soil surveys, don't seem to indicate real confusion about the soils in terms of wide discrepancies. And so the Conservation Commission was looking at a national evaluation system that has been judged in Maine to be just not practical. And did not provide any objective evidence saying that the soil mapping here is woefully inadequate. So, but you had a request from the Conservation Commission during the public input, so I put it on as a potential condition of approval, and the board again can either decide you feel they meet the soil mapping standard, or that they don't and they need this additional mitigation information, or that this soils are so bad on this project that you would deny it.
And we actually did ask for a response from the Conservation Commission. Granted, they're not a voting member here, but we asked for that because of their expertise, more so than anybody else on this board. So I would certainly agree that we would move forward with that.
Yeah, I agree. I also think that the peer reviewer for wetlands might be able to cover this as well, potentially.
And the other,
Sometimes they do multiple.
Well, the peer reviewer would not do a high-intensity soil survey, because a high-intensity soil survey is gonna be required them to get a backhoe out there or borings and do test pits over a much larger, they've done test pits just for the septic systems. To do a high-intensity soil survey, they would do a lot more test pits to verify where the soil boundaries at a much higher accurate level. So the town's peer reviewer would not do that. They would review it if you request them to.
I think there's different levels of a soil
Well,
survey.
A high-intensity soil survey is what is specified in the ordinance.
Okay.
It is an option.
Yes, the board can require it in areas where you think there's real questionable soils. Or if you had a higher density subdivision, it would be another example. Half-acre lots, for example. You don't allow that here, but many places they do.
and I just wanted to add, we just paid for our wetlands delineator to go back out there, because I know there was some question, when it was done, when the studies were done. And we actually have a letter from him. He just went out there on August 1st as well. So I can pass out this copy from him.
Let's hold that till we get to there is a wetlands question coming up, but if
Yeah.
you don't mind holding it.
So I feel like I don't know enough about this whole, why would we need it, why wouldn't we need it? It sounds like it's surrounded by wetlands. We've had issues with subdivisions near wetlands before in the very recent past.
But
I don't know, you're right, if it needs a backhoe on the whole thing, is that really something that we're requiring? So like, maybe
But
some.
But why did we request the Conservation Commission to give us feedback?
Generally, like, I think didn't we say generally we wanted their feedback, not specifically on, or did we? I'm sorry.
Yeah, well, I mean,
To what extent? I mean, you ask for somebody's feedback, then when they get into detail, it's to the point where, do you not want to accept it?
No, I hear them, and sure, do we want to just say, go ahead?
well, I think it's our call whether we accept it or not. I mean, and
It is.
our car being all,
Right.
our vote and stuff. My thought is, and I'm hardly an expert, but when I look at the soil logs on the 13 lots, it's all sand now. And a question I would have is, have we had a problem with houses in wetlands with foundations sinking, or was it they went into the wetlands by mistake?
The latter.
It's just, I mean, I don't know the history on that. But my thought is there's probably enough information out there, and at the end of the day, the builder / developer takes the risk of, if we get in there and we can't pass a proof roll on the road, or the foundation doesn't sit or whatever. I'm looking at Alan to see if he disagrees. He's shaking his head no over there, but That's my thought, anyway.
Here's another option. You could ask the Goral Palmer, who's the company that we're gonna be having, whether they would recommend a high-intensity
Yeah,
soil
that's what I was
survey or not.
leaning towards. What do you think about that, Alan? I know we heard from the Conscom, which they're very smart people, but this would be a third-party peer reviewer that could talk to us more about it.
Yeah,
You know.
I certainly don't want to impose something on somebody that there is no benefit from doing it.
Right.
Just for the sake of doing it.
Right, exactly.
Yeah, I don't want to impose an expense on somebody that, like I say, if there's no benefit.
No, to make
But again, 5 years down the road, I don't want us to be sitting here, why didn't we do that?
Right.
Because you can't imagine what we ran into, but if you had the third-party review, peer review, it should answer that question for us.
Yeah.
So specifically, we would ask the peer reviewer to give the board input on whether they think that a high-intensity soil survey should be required.
Mhm.
When we're asking something like that, does that delay, how much does that delay depending on the
Well,
availability of
What
that
we would
individual?
do is, basically, whatever again, I've already contacted Goral Palmer, and I've already listed the possible areas that they may be asked to do a peer review. They're ready to do it. So what we would do is have the applicant get their final plan to the peer reviewer. We would already submit whatever documentation we have, including this question, and then they would be able to do the peer review and then give that information to the applicant. So if the peer reviewer says, yes, soils are very questionable based on their review of the plans, then they could get that high-intensity soil survey done, submit it to the peer reviewer, and have it when they come in for the final approval.
So the peer review is ongoing during their final.
Yes, that's
plan.
part of the reason for having a preliminary and a final, is that you can get all the technical reviews done by an outside peer reviewer for whatever ones you're gonna require. Then that all comes in for the final approval, and you have all the information that you need.
Yeah, because I think I saw 6 months or so.
Has to be filed within 6 months, or they have to apply for preliminary over again.
I like that idea.
6 months.
See if Goral Palmer could do it,
So how do,
or could,
go ahead, I'm sorry.
sorry, could
Go ahead.
So
propose.
you would modify number 3 to have the peer reviewer consider whether a high-intensity soil survey is recommended.
Correct.
Are the applicant okay with that?
Yeah, yeah. I mean, yeah.
Okay. Anybody, any other comments from the board? If not, then on number 3, all those in favor of approval with the modification that the peer review by the engineer, I guess, would that be who does it? The engineer peer review would take a look at the need for a high-intensity soil survey. Raise my hand. 401. I'm not even looking at Ann anymore.
Like I'm not even here.
So the next one is 4, which is the issue of the offset of the intersection from Patriot Way across the road. And it was off diagonally, and they've moved within the right-of-way closer to a direct opposite. The question is, it's still offset a little, and is that an issue or not? If the board is concerned with it, that is a traffic safety issue, then the peer reviewer, they could require the applicant to have a letter from a traffic engineer saying that they consider it to be safe, and the peer reviewer would review that and make their independent determination. And if it is safe from an traffic engineering standpoint, they're good to go. If not, then they might have to do some negotiation with Timber Oaks to try to realign the whole intersection.
Doesn't the main DOT have to approve that?
And MDOT would have to approve it as well, but you have independent jurisdiction. As we saw in Wingate Farm, you don't necessarily have to accept MDOT's position.
I would think that if this is going to the main DOT, that, and we're recommending moving it, that once they say yea or nay, then we would go what Maine DOT says.
You could take that position.
Isn't it a 35 through there still?
Where does it
I think
have?
where it increases.
It's just down the road, ain't it?
I think it
You
is.
don't miss, it,
Pretty sure
it
it's-
misses you. I think the 35 is past, or short of it, or past it, depending on which way.
35 is just up that little hill right before the school, so it's still in the 50.
My input, I asked Calvin, because he had that concern after Windward, or, I'm sorry, the farms issue. Whether he, and he did not see this particular one as an issue
Right.
from the road commissioner's viewpoint, because I don't think he addressed that in his,
No, I didn't.
his email.
He did, sorry, he does.
Oh, he did mention it? Okay.
He does, he says, plans are not clear to that, the site distance is 700 feet to the south, please have plan clearly depicts site distance in both directions.
Yeah, I think that's the site distance, which is a different question. This
Oh,
is,
yeah.
this, yeah, the alignment of left turns, I would think.
Oh,
Since we're kicking everything else to the peer review, would, those folks,
Well, then you either do the peer review or you don't do peer review. This is not asking them whether they think a peer review is needed.
okay.
Why would we need to do that if the DOT is?
I mean, I'm good with just the DOT, main
am too.
DOT. We addressed that as a specific issue that they look at closely, so that nobody can miss it, you know, if you will. That-
Yeah, that's another option, is to have the applicant, have the MDOT address that issue in their permitting.
Yeah,
Mm.
and, yeah, I like his words better, which is they specifically address in their comments that your alignment is okay.
oh, we're talking alignment, we're not talking
Site-
safety?
Well, alignment has something.
Alignment
to
is
do
safety
involved.
too.
Okay. Yeah, there was some discussion with possibly linking in with that other landowner, right, with the road last
That
time?
would get it to line up, like.
Timber Oaks has
perfectly.
indicated a willingness to work with the applicant
Yeah.
to realign it, but that would require an amendment to their subdivision to do that.
Got it, okay.
So did that make sense, George?
So we'll have the applicant make sure that the MDOT addresses the offset in their permitting.
And if
In
not,
permit comments.
yeah, then if it's not there, then it's insufficient.
As opposed to getting traffic engineers involved.
Right.
Okay, that's that's 4. Number 5 is going down through the,
Sorry,
Oh, we need to vote on it.
oh, I'm
right?
sorry.
All those in favor of the words that we just described? 401.
what about the site distance part, though?
The
Like,
DOT will address that at the
Right.
same time.
Well, what it is the applicant's engineer indicated it's 700 feet in both directions, but on the plan, instead of using the arrow going in both directions, both arrows, either though it's on the other side, are pointing in the same direction.
okay,
So it's just like a typo
Oh,
on their plan.
okay. So there's no concerns with site distance on this,
No, he
this
just said-
location here, right? Okay.
And I think
Thank
we
you.
need, when we get there is, I think we need to take a look at what the road commissioner said and make that the appropriate one as
Yeah.
part of the conditions.
It's just a simple note on the plan, I
Yeah,
think.
I think it's like 350 is required, and
Yeah,
Calvin's
okay.
good with it. Number 5,
Did you vote?
Yes.
Yes.
Okay.
401.
Yep. All right, 5 is the response to the public comments. The first was a survey accuracy, which is covered by 2 above now. That changed because I took one out, and we're gonna come back to that one. The drainage concerns, engineering peer review should address, the neighbor asked for an independent peer review of the stormwater and erosion control. The timber harvesting violations, there's a later condition of approval. It says they either have to get DACF to come down and verify that there are no violations, or get a licensed surveyor. The only thing they've submitted is, Forester, excuse me. The only testimony so far is the testimony of the applicant that their forester said it was okay. That's not adequate documentation. D.
We're not ready to vote on number 5.
Yeah, I'm just gonna run you down through them. D is the disclosure of the encumbrances, we talked about that. And, do you want to Did I use the right language there? Ann, is that, what was the word, the term you used, summary?
Satisfaction of judgment.
Satisfaction of judgment.
Yeah, summary.
Yeah. Satisfaction of judgment, which hasn't been done, and the question is, do you want that to be a condition of approval? The accuracy of the wetland delineations, we'd get a peer review done. The location of the stormwater basin, now we're also gonna address that through the peer review. Right, recommendation. The sensitivity to stream crossings, DEP and Army Corps of Engineer permits will be required. And we wanted to address both the stream restoration and the new stream crossing. You have now documentation from the school superintendent on the schools, so you could delete that one. The aquifers, I've recommended that you would consider having the code officer review the standards applicable in the district boundary and see if it affects any of them. And then finally, on public input, the concerns for zoning violations. Again, if that's a concern that you have, you did the site walk, you've heard the testimony, you could ask the code officer to do an inspection to see if there are any current zoning violations.
Okay, so should we, there's a lot in here.
Yeah, what would you like, how do we go? We've covered, we keep punting on survey accuracy and drainage concerns. So what,
I think honestly drainage concerns we might be able to cover quickly here. Just by what's said, the peer review, right?
Mhm. Yep.
I'm good with that.
Shall we take a vote?
On 6C, who's in favor of the verbiage review?
5B.
5B, excuse me. 6B, the drainage concerns, who's in favor of the language as written? Please raise your hand. 401. It passed. Well, let's just kind of then take the rest of them, Jordan. The survey accuracy, is this the time to talk about, you know, take a vote on what we want? Maybe we keep kind of, this is the third or fourth bullet that we looked at.
I think in the ordinance it says for the preliminary plan, we need to have a up-to-date survey. And the applicant said they would be able to get it by the next meeting, so I think we should enforce that we have it by the next meeting before we can vote. We couldn't vote today to do it, so we can wait until.
Yeah, if you go in that direction of saying, if you have that in by the next time, we'll go with it. And what I would do is take whatever you get out of this and make all the changes and have that final draft ready for you. If they've got it, you can then make the decision to go forward, and without that.
The final draft of the conditions.
Yeah.
Okay. Any discussion on that?
No, I like
Any further discussion? I guess all in favor, do we vote on punting it down to the next month? I won't use.
Well, that's just that survey one, right?
Yes, the 6A.
Okay.
And 3 or 2.
We're gonna actually drop 2,
5A.
2 and 5A, drop those two because they're gonna address that for the next meeting.
Thank you.
Okay.
5A.
All right, now we're on 5C, Mr. Chairman.
Thank you, ma'am. On the new paper. Timber harvesting violations. Okay. So, I think we've all, in the past, and if I'm wrong, correct me, we've all said that we want to see either a certified forester or a Department of Agriculture look at that. So are you waiving papers because you've done that?
Yeah, the tree cutter who actually went out and did all the work, we have the letter from him saying that, you know, when he cut it and that he cut it all, you know,
Okay.
in compliance and everything
The
like
two
that.
documents that you've just referenced, why don't you give me the copies? And then for the next time, I'll incorporate those into the packet and the.
Okay.
the-
And you'll make sure that it's what we
Advice.
need, the certified, whatever it may be? Okay.
Yep.
Well, so can we figure it out right now if that is what we need? Is that from,
It's from Jeff Cody, is a registered Maine harvester, his certification number. He harvested lot 32, it's lot map 7, lot 32A in 2019. He harvested in compliance with liquidation harvesting standards set forth in Chapter 23, timber harvesting standards. He's signed and dated
And
it.
so that is the certified
That's the
licensed
That's the
forester?
certification that we're looking for.
Okay.
Yep.
And we can delete that as a requirement? Or,
You have copies?
Yeah.
okay. 5C is no longer applicable. Okay, now I guess we're on potential consequences. 5D. Satisfaction.
Wouldn't that be, it certainly could be a requirement of us, but since the selectmen have already voted on this, is it something that we feel is needed?
I don't, I mean, I think we know the the town manager said they voted on it, and, they've accepted the project, that they've released the money and the judgment is taken care of. So is there a problem going down the road if there's not some piece of paper recorded or whatever it may be? I think that's the question.
Can I just ask for clarification on what the selectmen voted on?
To my knowledge, what they voted on was to accept, the court ordered $50,000 in fine, and they accepted $25,000.
So that's different than the on-the-ground work has been done.
Yes.
Well, is it? I thought they did that after,
Yeah, they
somebody, Alan or something.
They cleaned up the site to the satisfaction of the select board.
Was there a vote specifically on that?
Yeah.
To my knowledge, there was.
I mean, it's interesting that they did, because with our site walk, there was still a lot of equipment that was left there that needed to be disposed of.
Right.
I don't
So
know
I
whether it's
think-
still there or not.
Yeah, it was after
It was after.
But I think we can cover that maybe in
Right.
J, that piece, possibly. Right, any existing,
Yes. Yep.
Yeah, that's true. That's true.
But it still goes back to the issue of, there's been a lien discharge because of the payment of the fine, but the court hasn't officially sanctioned the resolution, so that's the question. Does it need to
I
happen?
mean, the court won't do a review of it. The
Right.
satisfaction of judgment, both parties sign it and say, judge, please
Right.
file this, and the judge does. The judge doesn't
So there's nothing
look at the
really
property or, yeah.
Yeah.
So I think the question revolves around what the Board of Selectmen voted on, and there should be minutes of that, and that should be something that you should make sure covers both the money and the on-the-ground work that needed to be done.
That the vote does, because if I'm not mistaken, the code enforcement guy, you went out and looked, and even after the site walk, it was cleaned up some more, correct?
I
mean,
checked it after everything was done. I did make one recommendation for silt fence expansion, but everything else was done and it was clean.
So I think the work, we're comfortable, or I'm comfortable, the work is done. Then the next question is, I guess, the paperwork piece of it. And we can either decide we're set tonight, or we can check with the town manager / minutes to see if they voted to, seemed to me if they released the money before it was all done. So,
And we do have a letter signed by the town manager, saying that it was all paid and everything like that.
The select-
This is a notice of receipt of the $25,000 payment plus $1,245 for legal fees. Mr. Smith submitted a check number, letter acts as receipt, time of payment declares it full and in complete accordance with the adjustment as approved by the select board at their March 22nd, 2022 meeting. In accordance with that adjustment, the town select board declares that the payment above resolves the actions that led to application of penalties related to the violations. Is that adequate?
That's the town manager's characterization of it.
Right.
Right, so I think the question is, what did the select board vote on? If they just voted on the money, then you have the outstanding question. If they voted on the money and the performance piece, then I think you're fine. I just think you need to get clarity on what the select board voted on.
And
I
I-
don't think it matters, at least in my opinion, and I'm not giving legal advice. I don't think it matters whether that's filed with the court, right? I mean, if the select board wanted to vote next week that both pieces have been satisfied, I think that's fine. I don't think there are extra hoops.
My
but-
my understanding, the original $50,000 was a number that the selectmen threw out there, and they really didn't know what the costs were going to be. And that's why they decided on the $25,000. They wanted to make sure they were covering all of the cleanup costs, and
And, but
which they
doesn't,
felt they did.
but if maybe I didn't hear it correctly, does not the town manager say that that money was accepted because the work was done, or that's the wrong terms, but there, seems like there was words in there that they accepted it. I think maybe I just misheard, so.
Right.
But you pointed out that this is the town manager stating what the select board did, right?
Right, this is the town manager's characterization of what happened. This isn't the actual vote, is my point. And my understanding is that there were still violations as of this time?
Well, then that's based on someone's opinion. I don't think that was based on the opinion of the selectmen.
And I do have a draft condition of approval J, which says have the code officer go out and review it.
Yes. I mean, the select board is probably the only one that can determine, on the advice of the code officer, whether the terms of that judgment have been satisfied.
Right.
I don't think it needs to be filed with the court
Yeah, I don't-
for our
I don't
purposes.
either.
But I think you need to be really clear whether the select board has voted that the terms of that judgment have been satisfied.
I think why this really came up is there was a resident, when we went on a site walk, there was a resident that said, are you kidding me? That basically, that we accepted this $25,000 and we still have equipment out there that should have been disposed of, in their opinion. And when you look at it, you say, yeah, I kind of agree with you.
Yeah. I mean, and ultimately, it's the opinion of the select board that matters. I have no idea what their opinion is or
Right,
was
right.
in March.
If you had the code officer and J report to the select board findings, would that cover it?
I mean, I think the select board just needs to, I move that all conditions of the judgment against Dean Smith have been satisfied. I second it. Vote, everybody, right? And I don't think it needs to be harder than that. Maybe they did.
Yeah, I think they
Right,
did.
that's my question is, what was the motion? What was the vote? Was the motion just to accept this number in satisfaction and release the lien? Was this motion and vote to find that the entire judgment was satisfied? I have no idea. I don't think this tells you. I think this tells you what the town manager thinks the motion and vote was, right? Does that make sense?
Yes.
I don't think this needs to be hard to resolve, one way or the other.
So what I think I hear Ann saying is that we need to find out next day or two what they have, what did they say that it's been done? And
Part of the reason's been the chaos of that whole process of clerk and town manager and records are just. it's
Yeah,
been-
I'm not
it's been-
blaming-
it's
I
been
don't
a-
think
No, I'm just
it's their
saying,
fault.
it sounds easy to do, but it may not be.
Well,
But
it sounds
we
to me like it's in the town's court, not the applicant's, because it's been cleaned up, we've accepted it's been cleaned up, I'm
Right.
putting it the code enforcement guy.
Right.
Yeah.
And they've paid, and so now we just need to find out, is there
If
or
you
was there a
think
vote?
that's, if the majority of you thinks that's an issue that affects your decision on approving the sub-project or not.
I mean, I don't mean to make this harder, but it also doesn't impact right title and interest.
Does not or does not?
There's no lien.
Okay.
Yeah, I think
I
that
mean,
was-
I'm okay with what we've got before us and what's been done, that the issue has gone away, but,
I'd still like to talk about J, but definitely.
Drop D?
well, I mean, I guess we need to vote on that, right? On, which one are we back on?
5D?
I would move that we do drop B.
Yeah, I would too.
Sounds like a movement and a second, Mr. Chair.
Okay, anybody, we had a motion?
Yep.
I move that we drop D.
Second? All in
Yes,
favor
I
of dropping 5D on the new paper? 401?
You mean dropping it as in a condition?
As a
of
draft
approval?
condition of approval.
Correct.
Yep.
And then we're gonna we'll come back to it on J. So I think now we're on E, accuracy of wetland delineations.
Yep.
Recommendation is peer review.
We already voted on that. I haven't,
Did we?
yeah, 401.
Yeah, again, this is a repeat because it's addressing the public comments,
we got
to
too many.
verify
Okay.
that you've addressed all the public comments.
So are there any of the rest of these that are on here that we have not
Wait,
addressed?
Did we vote on that one?
I have it written down.
Okay. For wetland delineation? We
Uh,
talked about, drainage concerns. We talked about,
I don't think
I
we
think it
talked
was-
about
Soil
wetlands
survey.
yet.
Soil survey was the one we voted on, you voted on.
Yeah, we did. Get a high
But
intensity
not the
survey.
peer review of the wetlands yet.
so let's vote on that one.
I think the applicant said they have a new,
Oh.
whether it's already been placed out, okay.
So on that note, that's the same person that did your delineation. I think the idea is to have a peer review, so like a third-party reviewer.
Correct.
I would like to know, though, was there any differences, any
Nope,
changes?
there's pictures all included as well on all the actual stated wetlands
Yep.
of recent pictures, that are all printed out in that packet as well.
Okay.
And he states that nothing has changed, and it shows all the dates that he went out there from the winter, in May, and then again in August.
Okay. I mean, I think that that's definitely gonna help the peer reviewer,
Mhm.
the second go-round, so, maybe it will just be a check in the box for the peer reviewer, looks great, good to go. But I still think that it should be a peer reviewer that looks at this.
Which is E, right?
Right.
Is that because, I guess why?
Because, well, the first thing was it was conducted in the winter, in which delineation should not be conducted. And then second, because there are a lot of wetlands around this site, and we've had issues in the past with it. So I think it's a good idea to get someone else to look at it.
Okay. I mean, first reason is, I think, sounds like it's gone.
Yeah, we went out.
But still, the question is, are we comfortable with what their wetlands guy or gal did?
Yeah, that wetlands guy was on.
You have to come up and talk on the mic there, so he switched place with one of your friends in front.
Oh, bring another chair up.
Yeah. Man down. Thank you.
And who are you?
Johnny Snow. And, yeah, I remember what it said. What are we talking about?
Wetlands.
Yeah.
You're not as old as I am, so
I already forgot. Air
That's an
cluster.
excuse.
you wanted to say something?
Just that I think he was saying that, just to be clear, that was proposing a second opinion paid for
Oh,
through
yeah.
the,
Peer review.
okay.
Yeah, but the wetlands, certified wetlands delineator who did that was on the Conservation Committee of Durham, who did it. So I'm questioning why a peer review when a professional who has done it, and the concern was the timing of doing it, and then he just went back out and recertified his findings.
Oh, interesting.
Okay, so the question is, one of the questions we need to ask you is, do you, I don't know if it's a vote of 2-1 or how you do that, but do you agree with, if we decide to do that, are you supportive of the peer review? Or should we decide if we're gonna do it?
I mean,
first?
yeah, whatever you guys want to do. I'm just asking the question.
Ah.
I'm just trying to see why the peer review is needed on that when he just went back out to recertify his findings.
Yeah. And I don't think we've decided it is yet, we still.
I was just making the comment on that.
So I think my opinion is, even if, I can't remember his name, but I know who he is.
Alex Finnemore.
Alex, right. Even if he had done it the first go-round in the summer,
Yeah.
I still would want a peer review. This isn't against Alex or anything like that. This is a really large site. We've got a couple of lots that are in potential issue because of the amount of wetlands in those lots. So, we've got the Goral Palmer is probably gonna be the ones that do it. They're already looking at a bunch of other stuff. They could look at the stuff and be like, it's good to go. you know, I don't think, it can't hurt this project.
No, that was all my question was.
Can't hurt it.
Any other comments for, I mean, I think we've got, someone has done the survey, if we, or the delineation, excuse me. If we think, there's no reason to think they haven't done a good job, and I agree with winter versus August 1st. So that's my feeling, but it is a vote. Any other thoughts before we call the question? Hearing none. All those in favor of including this in the peer review, raise your right hand. Okay. I think it may have
Really?
failed.
Oh my God. Okay.
So I think it has failed. Now I gotta redo all the numbers.
1, 3.
1,
1, 3, 1.
3 is 1.
And we've already decided the peer review F on the detention basin. So then does the DEP and Army Corps of Engineers permits for the stream restoration and new stream crossing satisfy the board?
Being an ex-Corps of Engineers officer, I will say they do.
Nuh-uh.
Not
Were
that
you really?
I was, but
You really worked for DEP?
I was a Corps of Engineer. I was
Or
an
Corps of
Army. I was an
Engineers?
Army engineer. I did not do wetlands review or that
Well, then
kind of. I'm just sticking up for my old branches.
Oh my God.
Even if I was not a retired engineer officer, I would still think that that's how I've seen it done in the past, and they do a very thorough review of those things, and I'm sure DEP.
Wait, no. So the question is,
Is the permit good enough for, is that what the question, what the, what's
This
your?
addresses the concerns that were expressed by the
Yep.
public, and the board's position under this would be that the review by the Army Corps of Engineers and the DEP on the restoration of the stream, of the current crossing and the new stream crossing, would meet appropriate environmental standards, and that's all that's required of the applicant.
so I'd like to add a little bit more to this, the permitting in general of resources, resource protection, Corps of Engineers, all of that should fall under this, right? So whatever they go to the Corps of Engineers for, the Corps will work with them on.
Right.
But if they don't go to the Corps on certain things, there could be something that's missed, that we miss.
Well, it includes Department of Environmental Protection too.
Yes, but, so there's some comments by the Conservation Commission last time, and even by the DOT, Calvin, regarding permits, what's required. I think that was what I was looking for, is direction from somebody that knows what type of permits are going to be required here, and the impacts and all of that, and taking it beyond state and Army Corps, but taking it local to the resource protection as well.
You are the planning board reviewer of the stream crossing from the town standpoint. There is no other review. As part of this, you are required to grant a shoreland zoning permit for the stream crossing. Other than that, it's gonna be DEP and Army Corps of Engineers, and Calvin's comment was that the plans didn't show the footings of the culvert. They're gonna be crossing the stream, so he was looking for more detail, which those agencies will certainly require.
Right, so do we as a board feel comfortable in this arena as far as a permit for crossing that stream, resource protection, without any guidance from anyone?
Beyond DEP and Army Corps.
We're not gonna get guidance from DEP and Army Corps. For our own, you said our own town, right? Our own board, we have to look at that from right where we sit.
I'm comfortable, not just because I retired from there, but having seen this in previous life in a different state, they were never easy to get approvals from, and they do a very thorough job of reviewing that. So I'm comfortable with those two, but
But specifically, what does that DEP and Army Corps permit say?
So you are going for a new permit, new crossing,
Stream
right? But
cross-
you're also taking out a culvert, right? So
It's a stream crossing permit, I think it was in remove.
It's gonna be stream
Legal crossing,
restoration.
For
existing
Stream
both of
crossing.
those- For both of those things? For both of those, adding in one, taking one out?
Yeah, it was all under that DEP stream crossing permit.
I just don't, I don't understand it enough to.
yeah, my feeling is they're going to look at it very hard and in a neutral style. So I'm comfortable if they say it's okay. But anyone else?
Oh, I am too.
I call for a vote then. Those in favor of this verbiage relying upon environmental protection and the Army Corps of Engineers. 3-1-1. Schools, I think we decided that's covered.
Yes.
Yep, so you can drop that.
Oh, sorry, on that note, the school one, in the letter from, whoever it was, the superintendent, she does mention that there could be an impact. She doesn't say there will be no impact, right? She said that there could be an impact.
I think she said, somebody correct me if I'm wrong, she goes through that, a lack of I won't call it wishy-washy, but she, at the very last sentence, she says something to the effect.
Could potentially impact the Durham Community School.
But then her last sentence,
Or high school, yeah.
Yeah,
but then she says,
It's more likely than not that we would be able to accommodate
Yeah.
the number of school-age children living at homes.
Right.
yeah. So really, that's, I mean, we're not, that's more than we typically get, I think, that kind of response,
Yeah.
right? Like,
Yes.
And they
yes.
submitted
Well, it's a
something-
new superintendent too.
right, I noticed that, yeah.
and then the applicant long ago sent something for someone named Becky that said they could handle it. It was with the schools. I do
Becky
believe.
Foley, who's now retired, yeah. Okay, I just wanted to point that out, that it wasn't a no impact whatsoever. It
No,
was a,
correct.
you know, could
Thank
be,
you.
but probably not. Okay.
So we're passing on voting on that, I think is,
Are you
we're
wanna
satisfied
vote?
with the answer.
Yep.
Concern for impacts on aquifer.
I propose that you just have the code officer review the standards for any part that's within the Aquifer Protection District.
I guess my question, is there any that are in the aquifer, any,
Yeah, it's right
this
here.
project?
It's pretty small, I think it's this.
Yeah, it's the road from the right where Juliet is out to Hollowell Road. It's the only part that's in the Aquifer
Okay,
District.
gotcha. I'm comfortable with that.
Comfortable with leaving it up to the code officer, is what you're saying?
Have you, we got the code, no, I like Alan. Yeah, giving him the mission, yes. Maybe I don't like Alan, we'll give him extra work. Any other comments? Those in favor of having the Durham Code Enforcement Officer handle that? Right hand, 401.
And same thing on the zoning violations. Go out and see if there's any current violations.
Correct.
Anybody, that would seem to be his job, anybody, other comments? Vote please.
Yes.
401. Okay, so now I am confused because, and not keep beating this horse, but have we resolved the issue of the, whatever judgment that is, satisfaction of judgment?
Yes.
Is that's,
Yes,
we're
that's
good with
done.
that, okay?
Yep.
I did cross that off.
So-
So, number 6.
Yes, that is the issue of fire protection. Again, the applicant has proposed a 36,000 gallon fire pond, which does not meet the standard for 120,000 gallons. And so the question is, so this condition says they have to either put in 36,000 gallons in underground tanks or a 120,000 gallon fire pond unless the fire chief agrees to a lower amount for either of those with sprinklers.
And we're fine with doing the 120,000 gallon pond. We were just waiting on a response from the fire chief. This got brought up last meeting too.
Okay, so let's just, let's
Just-
make it
yeah.
120,000.
Yeah, that's fine.
Yeah. What do you guys think? Sorry, I'm not
Nope.
ordering you to do that. So.
They are
recommendation.
proposing 120,000 gallons. Does that satisfy the board that they meet the
Yeah,
standard?
it meets the standards.
Where is
So
that pond
you-
gonna go again?
I think it's at the end of that hammerhead.
Here?
I believe so.
Okay.
So you would not need to put, if you have the 120,000 gallon pond, you would not need to put the sprinkler system in the homes, correct?
Right.
Still a really good idea
Okay,
though. Just gonna leave that.
Okay.
And all of these lots are gonna be built fast. I mean, like, the road, there's gonna be access to that pond.
Yeah.
Yeah, it has to be
Yeah,
done
it's in
before-
the
it has to be done
HOA would
before.
own it or.
Yeah.
okay, so we're dropping 6 as a requirement to vote?
Or just specifying that it'll have
All right.
120,000 gallon pond,
Right.
which again, I'll clean up the wording.
Okay, let's vote to say that the,
What about if there's a right of way at the end of the hammerhead, the pond can't go there, or something's gonna have to adjust?
Pond will have to be located where it can go.
So,
They'll have to design that.
Well, no, have to.
or expand the pond at some point in time, or, all right, so what do we want to say to address the code enforcement's? They must build and maintain 120.
No, I think that the code officer was pointing out you can't have it off the end of the turnaround if you're gonna have the future paper street. They'll just have to, they won't be able to have it there,
Okay, so it has to be located outside the right of
outside of
way.
that. Yep.
You guys agree with that?
Yeah.
All right, so then the vote on verbiage that says that they will build a 120,000 gallon capacity water storage pond, and it will be built outside the right of way for the right of way extending to the property line.
Are we voting?
Yeah, I'm looking at George to see if he understood that.
Yeah, that's fine.
Okay. 401.
And now we can have the fire chief review too, right?
Yep. Okay, the 7 is one of the issues that's come up with the amount that's been cleared. That's a concern. The standard condition of approval says that they've got to show that on their plans, all areas intended for clearing. That's what 7 is about. The final plans will have to show that.
Yep.
And you guys good with that? Okay, I guess we vote on that. All those in favor is saying the final plans have to show the clearing plan 401.
And 8 is the MDO, you're gonna rely on MDOT permits for the intersection?
I mean, that's just, to me, that's an automatic. It would a vote. Is there any comments on,
Well, Calvin had a good point that you guys already have a permit, but that there's another one required that you might have already known about
can't use the one for the house?
Yes.
or something.
Yeah.
Okay.
You agree to that?
Yeah.
All those in favor of that language then? 401.
And the next one is the road extension showing on the plan.
We voted on that already, right?
That was, yeah, a change, but this is the addressing the specific standard for that.
All those in favor of number 9, raise your hand.
Southwest or south boundary?
Let's see, north, it would be south, I guess.
All right,
What did I put?
change it to south. So all those in favor of as written except changing southwest to south?
Yep.
Raise your right hand, left, whichever. All right, that one passes.
10 is a peer review of the road and stormwater and all that, which you talked about last time.
All those in favor of that? I mean, if you want to, you can stop me if you want to have a discussion about it.
These are the more straightforward ones.
This is a peer review on all the engineer plans. This one's specific to
We
the
already
road.
voted on the stormwater review,
Yeah, this is
right?
just the
Peer review?
road, okay.
Yep, yep.
All in favor, right hand, left hand, 401.
And the next one is the, within the lots, limiting the clearing so that the lot owners know what they're supposed to cut and not.
You guys have any problems with that?
No.
Just leaving
Anybody
a
have
buffer between lots.
Any discussion? Please vote. 401.
And the next one is the deeds also have to put the property owners on notice that they can't cut in certain areas.
Okay, any problems with that from the applicants? From the board, any comments? Vote, please. 401.
And you probably can drop 13 because you now have a letter from the forester.
Dropping 13.
And then 14 is the issue of those two lots, 6 and 7, where they have wetlands over considerable portions of them. And so one solution is to have a site plan for each of those showing the grading of the home and lot to show that it's not going to extend out into the wetlands. And again, that would be an engineered plan for those two lots, which they come in, and if a different builder wanted to do something different, they'd get an engineering plan, bring it into the planning board.
Does the applicant have any issue with that?
No, we can have, Charlie have a grade plan to that, yeah, that's fine.
Okay.
Right.
So no problems? All those in favor of this verbiage? Please vote. 401.
So the rest of them are just standard approval construction, approval conditions that set forth, this is what all of the technical things are gonna have to be done. Those were the substantive issues based on the review. So if you're comfortable, I'll just summarize each one of them down through and you could vote on them as a block.
What are we looking at?
The
One?
Part B is conditions to address other review criteria and standards.
The new
Thank you.
paper.
So 15 is the engineering cost estimates for the infrastructure, which is going to include the road construction, the electrical service, the stormwater management, the erosion and sedimentation control, and the fire protection system. 16 is just putting the applicant on notice that they've got 6 months to file for final approval, and if they don't do it within that time frame, they've got to come back for a renewed preliminary. 17 is the erosion and sedimentation control plan and the engineering peer review along with the rest of it. They've got to go to the code officer, who's the street addressing officer, to get a name for the street that should go on the plan. They got to check with the natural areas program to see if there are any rare plant.
They've already done that.
Yep. Again, that just goes into the final application. Same thing with the Maine Historic Preservation Commission, and the ordinance is required, and inland fisheries and wildlife for any rare animal plant habitat. They've got to get a bank letter based on the engineering cost estimate to indicate that they have financial capacity to do the project. 23 is a DEP stormwater permit, which is required because of the size of the road. And then 24 is a submittal. They've already also submitted covenants. We will check to make sure those line up with the town attorney's template. If not, they've got to get it changed or reviewed by the town attorney at their expense. And finally, 25 is they've got to show what kind of a performance guarantee for the engineered estimates of cost improvements that they're going to submit to the town.
You guys have done them before, so, okay. And sometimes it drags out a little bit, okay. All right, are there any comments from the members on any of those?
Can I ask a different question?
Sure.
I mean, get through this first, and then I just have one
You
more.
may ask questions. So, vote to accept these as written, I believe. 401. Man,
So this chunk here that's being, maybe you guys talked about this already, this chunk here that's being retained, is that coming with a right-of-way
Yeah.
over this? Okay.
It's right next to that first lot on the right before it. It's on a different set of plans, different page.
Okay.
We did talk about that.
Okay.
I think the first meeting that came up. Just to make you less scared that we've fallen apart.
No, I have full faith in all of you.
and not to drag this out, because I know we have one other applicant and another thing to do. I do have some things that I think are missing. They're relative, some of them we've covered, they're relatively minor issues. There are things like, addressing on the plans, wells and septic will be done in accordance with main rules. You cover the septic in the covenants, but not in the not the wells. There's a statement required on the plans that both will be done in accordance with, and I didn't see it. So, and I don't know that's not something that I would hold this up for. Fire protection we've covered. My other big worry, though, or concern is on, and I'll open this up for other comments, is the use of the common areas. So you've heard a lot of, in the last 3 or 4 meetings, a lot of concerns about the wetlands. My concern is, and I'm not pro or anti ATV, but how do you control people going into the wetlands and messing them up with, whether it be ATVs or walking or however it is? You do not cover that well in your covenants. You don't cover it at all in the covenants. So I would really like to see something in there, since it's all, since you're crossing streams, you're close to a waterland. I would just ask that when we review the covenants, that you take a look at that, and we can make that a condition if we want. But that's probably the biggest thing that we haven't discussed, is how do we keep from tearing the hell out of the wetlands and the streams and all that other stuff.
So by that, do you mean, so let's say there's like a trail system, and there's a marked trail with something saying that, please stay on marked trail.
Yeah,
Is that kind of what you're talking about?
I'm thinking that's something like that, but
Yeah.
also in the covenants, it would state specifically, you cannot, first off, there's trails cross the stream, so how are you gonna protect those? But then the other one is something that is there in writing, recorded. I never read my covenants and restrictions, but at least it's there to be punished with, which my HOA did. That says you cannot go into the wetlands with AT, or at all, but
Yeah.
I'm just trying to, some language that keeps people from tearing up the sensitive areas.
Okay.
Do I make that
No, I don't think you need to.
okay, that was my big concern. Anybody else have anything that we didn't cover in all of this stuff? So, having said that, what do we want to do? Are we comfortable approving with conditions, or denying this
Do you
evening?
want the survey for
Yeah.
next month?
Yeah, you kind of.
Yeah. Thank you.
Tabling this?
Yes, thank you.
Table it till
Table it
next
till
month,
next
and
month. Thank you.
I'll clean up this, and they'll get the survey in, and it'll be ready for a vote next time.
Okay. So is there anything I've missed on
Oh,
this one?
sorry, hold on. One thing, though, buffers. We didn't really talk about buffers. I don't know if we need to.
I thought
We just talked about that. We said we'd leave a buffer between each lot because we're going to show the
Yeah.
actual cutting envelope.
Yeah, no, I mean like in general, like from the road, there's not really gonna be a visual impact, right? Because you've got so much space.
Well, and you take that right turn.
And
Yeah.
each lot has that wooded buffer around it too.
Yep,
That's what that is.
and you've got all of the,
The 100-foot
Yeah.
stream buffers,
Right.
and I remember seeing that.
but, yep.
Condition of approval 7 says that areas intended for vegetative clearing shall be shown on the final plans to support the stormwater management plan assumptions and required buffers along water bodies shown on the recording plan and referenced in the plan notes.
Yeah, and actually, can we go back to that open space? Sorry, I heard you talk about it earlier. So the proposal is a trail, kind of like what was proposed at Bowie?
Same exact
Similar?
thing. Yep.
Okay.
It was marked on there, the perimeter.
Yeah, so, like stream crossings, wetland crossings, things like that, are you
We-
gonna propose?
Yeah, we talked about putting all those walking trails. They have like the logs down and you walk across, stuff like that.
Okay.
Yeah.
Anything else for this evening? If not, we'll bring this to a vote next meeting if you get us the stuff that we asked for. Okay. I think we're good. And we missed anything? If not, we can release these gentlemen and ask the next participant, next applicant.
Victim, just kidding.
Does anybody need to use the restroom? Anybody on the board? Thank you, guys.
Thank you. Thank you.
Tyler second, while we're swapping out applicants. So our next, this is new business, conditional use application of Celebration Tree Farm for camping, public workshops, and events at 125 Bowie Hill Road, map 10, lot 43. And Jordan, would you like to do an introduction, then we'll ask the applicants to,
As I indicated in the agenda notes, the applicants are applying for a conditional use permit to expand activities at the Celebration Tree Farm on Bowie Hill Road. Some of the proposed uses do not clearly fit within the table of uses. The applicants did go to the Board of Appeals for clarification on the interpretation of the resource protection boundary. The board denied that application on the basis of the town meeting vote on the zoning map, and also because they felt that the proposed activities do fit within existing allowed uses in both the resource protection and the rural residential and agricultural district, and I did include a copy of their decision in your packet. The application addresses the conditional use criteria. And in 2021, the board, I just wanted to clarify for the record, the applicant had submitted a different conditional use application for about 20 campsites on the land to the rear of this property. And part of that discussion was a camping bus on this property, and the prior code officer had issued a cease and desist order for the use of that bus because it didn't meet code. And the current code officer has verified that that bus is not being used at this time for camping purposes. So, as I said, this is a different application now, and I've drafted potential findings of fact following the applicant's submitted application, which you can add to or modify based on your discussion with the applicant tonight. Per section 7.3, the board must again either approve it without any conditions, approve with conditions that you feel are necessary to meet the conditional use criteria, or deny the application if you feel that it fails to meet any of the conditional use criteria. You can put conditions of approval by majority vote, and for specific areas would be increasing the setbacks, in requiring buffers, limiting hours of operation, and/or location of parking and signs, and you can apply other conditions of approval that you think are necessary.
anything else?
Just the criteria that you'll be reviewing under the conditional use include the public health impacts, traffic safety, public safety, environmental impacts, scale and intensity of use, noise and hours of operation, right, title, or interest, financial and technical ability, and specific performance standards. The applicant has said there are no other specific performance standards and to their activities, and they've addressed all of those criteria in their application.
Okay, before we get into the applicant's presentation, I think a couple of things to discuss with the board. One is a public hearing, correct me if I'm wrong, is not required for a conditional use approval. However, I'd like to discuss, should we have one? We obviously can't do it tonight, so we would do it at the next meeting. And then number two is, do we want to do a site visit to the Celebration Farms? And I think, when does it fit in your calendars? So the discussion about doing a public hearing, and we would, if yes, do it next month.
Yes.
Anybody going horizontal with your head shakes? It's not required. It's But I think we've talked a lot about transparency and including the community, and not that you've got a bad project or anything like that, but we'd like, because we've already got a letter from somebody supporting you, so I would assume that you would have folks that, we would probably see people on both sides of the fence on this one.
We were under the impression that the public was invited tonight to comment.
Yeah.
Different. No, it has to be a formal public hearing where we open it. We have to give a bunch of notice, and so we can't do it this evening.
Okay. I guess, I was just mistaken. I thought that was part of the butters notice and talking to neighbors, but.
No, not this
Okay.
evening. So we would do it next, if we agree, next meeting. Okay, we'll take a vote. All in favor of doing a public hearing next meeting?
And a sidewalk, or do?
Oh, sidewalk would be a
Sidewalk,
different date. I'm sorry.
Yeah.
5:00 to do the public hearing, and then is there a time that works with everybody's calendar? Site visit is we come to your property, you give us a tour, showing specifically what you want to do and where. And that would be open to the public, and we also have to give them notice that the date and time we're gonna hold it, so.
So you would recommend either the 22nd or the 29th?
Those weeks, if you would, we have a town meeting, and I'm out of town the week
Of
of 50
September, August?
August. Any time.
What if, could we do it right before the meeting? No.
Yeah.
You wanna do that?
Why not?
Yeah.
Yeah.
Done it
Saying like
before.
as in of,
The day, the 7th, right?
So if we start, so we start at 6:30, site visit would start about 5.
5:30, 5:30, yeah.
Want to make sure we have enough 5:30. Can we get it done in 45 minutes and travel time? That'd be my only concern.
Would be tight.
We do 5.
Yeah, I was thinking 5.
Would 5 work?
I'm retired, so I can make any time work.
Tyler, would 5 work?
yes, sorry, I was just checking sunset time, time.
Oh, yeah. Good.
Okay, that's good.
Yeah, that's good.
We're still,
So that's the 7th, right?
The 7th at 5 p.m.
does that work for you guys?
That does work for us.
Okay.
as well.
Okay.
Yeah.
That's a good question.
We'll just show up whether you're there or not.
Yeah.
We're happy to water, but that's the intent, was you would be to show us what you want to do and where, and we'll ask you questions about the property and all that other kind of stuff. So I think we've killed both birds. This is my opportunity, since you're new here tonight, to kind of lay out one other rule, which is, there's some fancy Latin name for it, but no one is allowed, there's no contact with the planning board members by the applicant, by the public, or whatever. Please send, and if you're gonna ask people to write emails, and we got one, please have them send them to the town planner. And he is very good. If you have any questions about how the project's going, or specific detailed questions, Mr. Thabarge is the guy to go, and he is very good at getting us the information. And that will apply to anyone sitting in the audience as well. So with that, it is now your turn.
Great. Well, hello, and I want to thank you all for being here today and taking time to hear our proposal.
One last thing, introduce
Yes.
yourself, please.
I was just about to do that.
Oh,
But
sorry.
I was thanking you first.
All-
Yes, we're all going to introduce
There
ourselves.
we go, thank you.
Yeah, and I know being on the planning board takes a lot of time, and there's probably better things you could do on a summer night, but I want to appreciate everyone for being here. I also appreciate the public for coming, even though there's not public comments tonight. So thank you. My name is Jonah Fertig-Bird, and I'm joined tonight with my wife Elizabeth Fertig-Bird, Tom Prohl, and Jeanette Huff, and together we are the 4 worker owners of Celebration Tree Farm and Wellness Center. And Elizabeth and I have lived in Durham for 7 years. We moved here because we were looking for a community where we could put down our roots, raise our children, and where we could farm and bring people together to connect with nature and one another. I grew up in Yarmouth, 15 minutes from here, and I've worked in food systems for over 20 years, working with a wide range of different nonprofit organizations and local businesses, helping farms and restaurants to start up, including Local Sprouts Cooperative in Portland, a restaurant that focused on local and organic food, supporting local farmers. I've also worked in education, teaching kids cooking and gardening, and teaching adults how to create cooperative businesses that support the local community. Additionally, have helped develop community spaces for people to connect with each other, hold workshops and cultural events like variety shows, art shows, and small performances. In addition to my role at Celebration Tree Farm and Wellness Center, I work for a foundation that provides funding for organizations that work to support people, animal, and the environment. I'm just going to have everyone else share a little bit about themselves as well, so you all know who we are.
I'm Elizabeth Fertig-Bird. Good evening. And I've been working in the wellness industry for about 20 years now. And I was really happy when we found this house because it's been a long time dream of mine to have a wellness center and to provide opportunity for people to really learn about themselves and how to become more healthy if that's what they are looking to do.
Hi everyone, I'm Jeanette Huff. I've been an educator of K through 12 university students and adults for 25 years. I'm also the wreath maker and manager over at the farm. I also manage nonprofits and run my own dance company called Apparatus Dance Theater.
Hello everyone, my name is Tom Kroll. I'm in addition to working and being worker owner at Celebration Tree Farm, I'm the farm operations manager at Wolf's Neck Center for Agriculture and the Environment in Freeport. I've been there for about 8 years. So my background is in organic farming, whether that's specialty in fruit and vegetable, forestry, as well as dairy and poultry. I have a long history of education. I start and I'm currently running farmer training programs. So I have an emphasis in education and chemical-free organic farming and a background in ecological forestry, which I brought with me to Celebration Tree Farm and continue to grow there. Nice to meet you all.
Yeah, so I wanted to just give you a little background first and then share more about our proposal. So Elizabeth and I co-founded Celebration Tree Farm and Wellness Center in 2015 after we purchased the farm from Diane Ackerman after the passing of her husband, John Ackerman. Diane wanted to sell the farm to us because we wanted to carry on John's ecological and community vision for the land. John started the farm in the 1980s and practiced ecological forestry and organic agriculture. He welcomed the community to come to the farm to cut trees for the holidays, share his art, and was active in the community helping to start the Conservation Committee, Androscoggin Land Trust, and helping to preserve land in town, including Runaround Pond and also the Durham River Park. We've sought to carry on John's work on this land and continue his ecological forestry practice and have grown the farm over the past 7 years. And over that time, we've become one of the only certified organic Christmas tree farms in the state and have developed a strong base of customers who come to get their Christmas trees every year. And just this past year, we became solar powered as well. We started the Wellness Center to offer more educational programs to the community and to support people with healing and wellness. We've offered small yoga classes, private yoga, personal training, and Reiki sessions in a studio in our house and sometimes outside amongst our garden. And during COVID, Elizabeth started offering these workshops and private sessions online. And then in 2020, we converted the farm to a cooperatively owned LLC with the addition of Tom and Jeanette. And then also in 2020, the adjoining 110 acres of forest land was bought and preserved by Land and Common Community Land Trust, with whom the cooperative has a 99-year lease. Last year, we launched the Community Supported Forest program where members get a tree, wreath, discounts on our wellness programs, and year-round trail access. There are now over 90 community-supported forest members and are excited for the growth and vision of Celebration Tree Farm and Wellness Center. When we moved here, we had the dream of sharing our land, bringing people together so they could learn, connect with nature and the forest, share their creativity, and grow community. Our proposal that we're bringing forward to you today is a big step towards realizing that larger vision. Just to give you kind of the overview of the proposal, we're seeking to create a non-residential educational nature interpretation facility, a single campsite, to use our historic early 1800s barn as a cultural facility and community building. This will allow us to continue our farm and diversify our offerings by expanding into agritourism and educational and nature programs for the community. All of these new and expanded proposed uses are on the 8.3 acres that Elizabeth and I own and live on, not on the 110 acres that Celebration Tree Farm and Wellness Center leases from Land and Common. Throughout our proposal, we've sought to limit any negative impacts and increase the positive impact on the land and the surrounding community. So So the education nature interpretation facility falls under the small non-residential facility for educational, scientific, or nature interpretation purposes, number 44 in the Durham Land Use Ordinance. We're proposing to build a temporary structure, a 30-foot diameter yurt, which will sit on above ground concrete footings. We'll use this facility for year-round educational workshops on wellness, farming, nature, environmental issues, and art. Accompanying this facility will be a single campsite in which sits the celebration bus that was converted into an RV. Since there is only a single campsite, it is not a campground, which is defined as 2 or more parties in the Durham Land Use Ordinance. The campsite will be used under 6 months a year and allows guests from near and far to stay on the farm and learn about organic farming and support their wellness through our educational programs. There's no running water on the celebration bus. The Bonnie Cobb has designed an expansion of a leach field system that will accommodate gray water from an outdoor shower and a sink. We'll have a composting toilet, and we'll properly compost the waste according to the requirements of the town and best practices of composting. And the bus will be off-grid and use solar, electric, and battery-powered lights, and have a propane grill outside the bus for cooking. There's a small campfire ring used for our guests, and use of this will be conditioned on fire hazards in the area and strict fire safety guidelines. The second part of the proposal is to use our 1800s barn as a space for cultural and community events, including monthly community variety shows and other occasional performing and visual art shows, educational programs, and our annual celebration market, which provides a holiday market for over 25 craft and food vendors in November for the past 5 years. This event is held on Shop Local Saturday and promotes the support of local artists and craftspeople. It will make the barn and yurt available for rental to our community forest members for family events, including weddings, no more than 2 to 3 a year, birthday parties, baby showers, and memorial services. Most events will be small, under 30 people, with our weddings having no more than 100 people. The barn has been in this location for over 200 years and has provided space for agricultural and community uses over that time. So this use lines with 2 land uses in the Durham Land Use Ordinance: clubs, lodges, and other community buildings. While there's no stated definition of this usage, like the AMVETS Hall or Masonic Hall, we'll hold events that are only for our members. And our members can rent the facility, and we'll hold also community events as well. And also there's number 21, the institutional and cultural facilities. The definition there is not-for-profit facilities dedicated to a public or philanthropic purpose and intellectual endeavor, such as a library, museum, auditorium, or performing or visual arts center. We fit the latter part of this definition because we'll provide space for performing or visual arts, and we'll be partnering with nonprofits to hold these cultural programs. So in our proposal, we've addressed all the performance standards in 7.4 of the Land Use Ordinance, and now these proposed uses that we've detailed here have additional performance standards. We've addressed in more detail, but just to mention the different standards and how we're addressing them. So fire safety, we'll have strict fire safety policies, include all campfires need to be attended at all times, fully extinguished. We'll work with the code enforcement officer and fire chief to ensure that all of our spaces have proper smoke alarms, fire extinguishers, and egresses. And all the proposed areas are within close proximity of Bowie Hill Road and accessible to live fire and emergency vehicles. Noise, well, we recognize there could be some noise generated from events. Most of these events will end before 9 p.m. with the occasional event ending at 10. No more than 3 a year. Required hours are between 9 p.m. and 9 a.m. We've talked to immediate neighbors, and none of them have been concerned about the noise generated so far by our variety show, celebration market, or other activities. And we'll continue to check in with the neighbors, to make sure that that's not an issue. Parking and traffic, we'll expect to have limited traffic for what we're doing there, with average daily traffic to be under 10 cars a day, and most likely to be under 5. And then we'll have special events such as educational workshops or retreats will result in increases in day traffic on our property. And for these events, vehicle traffic will be limited to 20 vehicles, and for weddings, a shuttle will be required for additional guests. Our Christmas tree sales and cut your own operations, we do have increased traffic, for which we use a temporary overflow space to accommodate this increase. And then parking staff has been used to facilitate that parking and make sure that people are not parking on Bowie Hill Road. And then water, addressed that previously with the leach field to accommodate gray water and composting toilets. We also commit to composting food scraps and using compostable materials as well. So that's the summary, and just give the background. Over the past 7 years, we've been in communication about our different uses of what we're doing with Bob Forrest. We came before the planning board in 2018, and at that point, the planning board determined that we didn't need any additional permits for our tree sales as they were under agricultural use. We talked to Bob Forrest about the wellness center, tree farm, and campsite, and he verbally approved those under the agriculture and home-based businesses uses, and since the single campsite is not a campground, we didn't need a conditional use permit. So we rented that out from 2019 to 2021 on Airbnb. The Celebration bus had 5-star reviews and no complaints from our neighbors until the letter that we got from Bob this past fall. And so then at that point, as was stated, we stopped renting that out. And we have, basically been working since November of 2021 to try to get to you all here today. As you know, Bob left, then we worked with Calvin, and then worked with George. And as was stated, we went to the appeal board because we thought we needed to do that first. We did that. We submitted that in May. We had the appeal 2 months later. And so we are now here today to bring this proposal forward. So it's been a journey to get here, but we're happy to have this proposal before you today. Just again, want to thank you for your time, for hearing the presentation, reviewing your application, and we look forward to hearing your questions, concerns, support, willing to evolve our proposal and be flexible so that it's the best fit for Durham, our neighbors, and our farm. We're open to your feedback and want to work with you to help bring this exciting vision into reality.
Okay, thank you. So we are going to have a public hearing last time. Do we have any general comments? We'll get into further discussion after the public hearing. Do we have any comments from the board prior to that?
I'm wondering what use this should be under, or multiple uses. I don't know if we can decide that tonight or not, but you know what I mean?
I think they've identified 2 that they think apply, right?
I'm actually seeing 3.
3 that they think.
So there's 2 different uses, right? The proposed use number 1, proposing under number 44, right? And then the proposed use number 2, potentially under 11 and or 21. And I think the appeals board agreed with the first one. A campground has 2 or more parties, and the bus will only have 1.
Yeah.
Right?
Yeah, and the second one, which either 11 or 21, wasn't talked about at the appeal board meeting because the barn is outside of the resource protection zone. So it wasn't part of the conversation there. Yeah, so they had shared their opinion on the bus and the yurt within the number 44, but not the second one because we didn't present it to them for that reason.
Are we all good with the first use?
Again, let me
Sorry,
step back. Let me step back just a second.
Mhm.
So what is it that if there are uses that they're now doing, the educational stuff, the yoga, the Christmas trees are a separate entity, what is it we're giving them that they're asking, we haven't yet decided to give it to you, they're asking to do that is not currently allowed under resident RA?
I think it's the camp, the bus, and the yurt, right? In the resource protection?
The yurt's not.
So it's the bus.
Yeah, I mean, we're including the campsite with number 44, although there's no, I mean, again, campground, there's definition, does not say, you know, a placement of a single campsite where that, you know, where that falls under the code, but we're including that because it is part of our educational purposes.
I guess what I'm trying to get to is camping one campsite allowed under the current use? Is that we're asking for an exception to that? And then obviously you want to build a yurt, a structure. Are the addition of that structure, does that require a conforming use? Obviously it would require a building permit, I would assume.
Okay, so you've got in the code, 11, 21, and 44 are all conditional uses, either in the RRA or the resource protection. So they have an existing operation using existing facilities. They're proposing an expansion of the conditional use to add additional facilities. So I think that's what they're looking for, is an expansion of the current
additional facilities.
Conditional use.
But the education, the wellness,
Well,
yoga,
I don't think they have a conditional use, right? They don't have an existing conditional use. Well, there's a permissible one. I'm not sure that's true, but that's not before us. So I think this is two new conditional uses.
A new conditional use application, okay.
Right? I don't think we need to get into whether the existing uses are appropriate or not.
Okay.
I
and
don't
then
wanna touch that.
Can you have two separate uses on one lot and just like split by like where the area is? Is that how it would work? Like, for this one, it would be by the RP, resource protection, right? That's kind of because you're gonna move the yurt around potentially, right?
I mean, the yurt's, it's movable, it's a temporary, you know,
Yeah.
officially temporary structure. As on the,
The bus is
site
staying.
map, yeah, I mean, both can be moved. On the site map, the proposed yurt location is just on the outside of the resource protection zone. The campsite is in the resource protection. And then the barn is outside of the resource protection zone, it's for residential.
So, can you tell me the first use that we're talking about in the RP, what was it?
44.
Yeah, thank you. The, non-residential facilities for educational, scientific, or nature interpretation purposes. Is that just the campsite? What is that?
That's the yurt and the campsite.
Okay,
Yeah.
and then the barn is your club,
Whatever.
Lodge,
Community building, institutional cultural facility.
okay.
Well, I don't know if the yurt is falling under this, right? The yurt is falling under the other two uses. 44 is just for the bus.
No.
Do I have that wrong?
No,
Sorry.
I mean, the yurt is included with 44 because it is, I mean, that's an educational facility. So that's where we'll be providing workshops.
Okay.
Yeah.
Okay.
I mean, we may do some workshops in the barn as well, but primarily the yurt, that purpose of that will be for educational purposes, like to do yoga workshops, do workshops on organic farming, do workshops on other topics as well.
Okay.
So how is the bus part of that use?
Because it's part of us, providing a space, because we'll have folks that will be coming to these workshops, having a space that they can, stay on the farm and also learn. I mean, farm stays is really something that a lot of people are doing, to be able to learn about organic farming. Also, they're learning about wellness. In the past, we've had our guests, who have done personal training, done wellness programs with our wellness center. So it really allows us to be able to have that ability for folks to engage more deeply in their learning and agritourism on the farm.
So I want to separate two ideas. I don't think you have agritourism on the farm because the agriculture is on a different parcel. that's owned separately. I don't think we need to go there. I'm just gonna put that there. But will it be a requirement of folks who stay in the bus that they engage with this educational piece, or will it that they're attending a workshop or that they're participating in wellness activities or something like that, or is this just somebody who wants to shop in Freeport?
No, not a requirement.
Okay.
I mean, our organic gardens are right there as
Mhm.
well. So it's, I mean, our farming happens there and on the 110 acres. So it's not yeah, I mean, if you walk from where the campsite is, there's a hoop house right there, and there is also a half-acre organic gardens as well.
I think what's confusing me, and maybe it's just me, but there's two parts to this. One is you want to add structures, or you want to add a structure. Now you use the bus for part of this and use the barn for part of that. So that's a build something, remodel something use. But conditional use is you're already doing things that are required of conditional use. Correct me if I'm wrong.
No, they
No, the
never
education-
got, they never got conditional use.
Yeah, they require, but my question is, does the yoga, the educational require a conditional use and you don't?
The
Whether you,
previous code officer told them they didn't need it.
Yeah.
okay,
Right.
And, you know, really, I mean, all of that has happened at a very small scale. And so that's where, you know, it was deemed as being a small usage, and then with the tree farm being, you know, our primary business, and what we did at a larger level. And, you know, over time, our tree farm has grown, and what this is, you know, again, really trying to move forward in a larger vision so that we're able to do more for the community ultimately. You know, provide more space for the community, more educational programs, and, you know, coming to you all so that we can do that in a way that's, you know, meeting the approval of the town and addressing concerns. And, you know, it's clear, you know, clearly this obviously is a different proposal than what probably you're used to seeing. It's not a subdivision, it's not, you know, so it's, I understand it's, you know, kind of, how do we make this work? And that's what we're, you know, we wanna work with you to figure out how do we make this work so we can realize this vision together, and have something that can work for us and for the town.
yeah, I think what I'm trying to wrap my hands around is that if, and maybe it is because we said it was long ago, but I'm not sure we have to stick with that anymore. But if yoga, just those educational stuff, wellness stuff, educational wellness, if that's requires a conditional use, that's one thing. And then there's so if we grant a conditional use for this land with the big, you know, the if, then putting up a yurt is then part of a site plan approval of that conditional use. But first is, are we okay with the uses? In my mind.
So I'm looking at it a little bit differently. So the existing uses have been going on for a while.
Okay.
Whether they've been going on appropriately under the land use code or not is not our problem tonight. That is the current code officer's problem. If he disagrees with the interpretation of the previous one, I think they are asking for new conditional uses, and that is what's before us. So I don't think the yoga that's currently happening
I got you.
and the Christmas tree sales that are
I
currently
agree with that
happening,
stuff.
I don't think any of that's before us tonight.
Got it. But the educational potentially is, right? Or have you been doing, I mean, I guess what I'm asking, are the uses, educational, wellness, Christmas trees are different because it's not on this particular parcel.
Well, they're selling them on this parcel,
Okay, and
and the
then
market is on this parcel.
we need to, yes, then that should probably be part of the discussion as well. We're trying to sort this out so that
I mean,
the
our
next meeting,
understanding, yes, that agriculture is allowed, I mean, under RRA, so that's why we're not coming forward for an agricultural.
I got you.
Because it's allowed, I mean, under number 3 agriculture, so, yeah.
I hear what you're
That's why we have
saying.
not come forward for that.
Yeah, but the Christmas trees are being grown on a different parcel, right?
They're, I mean, being grown by us on an adjoining parcel that we lease, and so.
But that you don't own, right? It's
Yeah,
It's
I-
a different parcel, it's a different
Yeah.
parcel.
Many farmers, I mean, lease additional farmland. And so, I mean, that's, again, we, like Tom at Wolf's Neck, they had the farm where they were based, they also lease additional farmland as well.
Very few farmers own their land these days.
Mm-hmm. Right, but a lot of them have situations where they're selling from the same parcel that they're producing on. And that's not what you're doing here,
Sometimes,
right? You're
yes.
producing on a different parcel and they're also not in Durham, right? So, or in a resource
Well, I mean,
protection.
yeah, I mean, I'm just saying, in general, it's not uncommon in agriculture to have your farmland and have your front of house on a totally different piece of land, oftentimes miles away.
Yeah, nope.
In this case, we have a 99-year lease, which, I mean, is very similar to actually being owned, except we use the community land trust that is permanently preserved as a community land trust.
So I think what we're pointing out, the goal today is point out issues that we need to resolve before we vote yay, nay down the road, and that's one of them. In my mind, I'm still, I hear what we're saying is that it's, that somebody said it was okay, and it's up to the new code guy to decide that. And if it is, anyway, that's an issue I have to resolve before we come to a vote, at least in my mind.
I think the question is, what are we approving, right? I
Yes,
think that's
thank
what
you.
you're getting.
That's what you're much more eloquent than I am, man.
What are we approving? What is in front of us? And they framed it as, we're approving a new educational use that includes a yurt and a campsite for the new educational use that is not happening right now, in theory. And a second new use of the barn for external gatherings.
Okay.
And just to, my memory of the conversations before the planning board previously, where we weren't concerned about the market, the selling of Christmas trees, because it was agricultural. I think those properties were combined at the time we had that conversation, or we just didn't ask the right questions, whatever. And then the second question came up, well, agricultural is selling your own products, right? And so the question came up about the market that they have, and those, the planning board said, so there's a provision in the ordinance for like occasional events or one-time events that can be permitted by the select board, and that was our guidance, is that it wasn't an ongoing issue, it could be permitted as these one-time events by the selectmen, and we didn't need to touch it, it wasn't an ongoing use. That's where we were, I don't know, however many years ago we talked about this. Yeah, so, I think ownership has shifted since then, uses have shifted since then. The previous code officer was fine with it. I don't think those are in front of us. So I think it's being framed as two new uses that are not currently happening at the property.
To that point, let me ask you, when I looked at your website, what was the retreat you held on July 30th of this year?
Actually didn't happen.
Okay. Answers the question. So we're not doing things now that you haven't been approved for, okay? Well, those are my concerns that we've got to wrap our heads around, and George, with your help and yours, defining what it is exactly that they're asking. It may be that I'm the only one that doesn't get it, but I'm struggling with it right now.
I think it's messy.
Yeah.
Right, I think it's messy because it has not been had clearly handled through the land use ordinance. So I think that's messy.
And maybe we need to lay it out and say, okay, the things that they want to do are doing are selling Christmas trees and wreaths and other things. They've done wellness, they want to do educational. Am I missing something there? Those are the three big topics, right?
The community
The
cultural
community, the wedding, the venue to hold meetings, that kind of stuff.
shows and things.
So those are the four different things. And what do we, what do we think has been, I'm looking at the new code enforcement guy as well to say, and just because it was, doesn't mean it's, in my mind, still is okay to do. Because I think the yurt and camping thing are, if we approve the use, then it becomes a building code thing to approve the yurt, if I'm not mistaken. I mean, we need a site plan from you all and, you know, prove that the yurt can go here, the toilets can go, all that safety stuff, water, leach fields, all that stuff you've talked to, but I am really confused on the uses, and I'm glad I'm not the only one.
I feel like there's two uses, right? I really feel like we should be separating the bus from the rest of it.
Well, the bus and the yurt go together.
But the yurt isn't, I'm looking at the bus as a campsite, as Airbnb, right? That's what that's gonna be used for. The yurt isn't, that's for your educational still, right? Which is what the barn is for and all
So
the other
what
things.
use is the bus?
I don't know. I mean, there's a campground, but that's for two owner, whatever, people are up.
What way?
It wouldn't be a campground.
Right.
Wouldn't, but what, like what category would this fall under Mubeck? Is this,
It's an accommodation, living quarter,
Move back. It would be a campsite, which you could allow.
that there's a structure
There
that
is a
people will
structure,
be
but-
sleeping in?
Yep, so it would be a dwelling that they wouldn't live in permanently. But I believe it's time, so in 2020, a bill passed that talked about additional dwellings on parcels. So the prior code officer noted that the reason that the stop order, cease and desist order went in was the bottom line is you're not allowed to have a second dwelling on one parcel. That's the letter that the code officer gave. But that's currently in direct opposition. Our ordinance is in direct opposition to a state law that passed in March.
so
of
but
2020.
we've not changed the ordinance, that we're working on that now.
Yeah. So I think that would be allowed as a dwelling, is what I'm saying.
So, but if it's a dwelling, it has to meet the IRC, right?
It has to meet the building code, which I've been to this site and I've talked to them about discrepancies. But other aspects that were noted in the letter could be addressed. And I talked to Jonah about those things, electricity, fire.
And it sounds like you're working that, but I think, I agree with Julie, I think that said, this, and somebody asked Ann or somebody, whether you call it an Airbnb or whatever you call it, you know, and I'm not sure the new law, we need to we're gonna talk about that actually after this, we have time, allows temporary, whatever, Airbnb, it doesn't automatically say it's okay, I don't think that was the purpose of it. So that is, I think, something we need to resolve, is the use of the bus, and then the other one, because the yurt to me is if we approve the use, if we approve the use, and we approve the yurt if it meets all the requirements with it.
So I guess my question about the IRC is trying to figure out what use is this bus? And if you're telling me it's a dwelling, then that's a residential use. If it's not a dwelling, it's not a campground, I agree with that.
But it could be a campsite.
I mean, for all intents and purposes, there's no water, there's gonna be no hardwired electrical or otherwise, it's really just, I mean, it's really like a lean-to on, I mean, for the kind of use of it. It's
Primitive.
Metal tent,
place
yeah.
to sleep, and it's a groovy little thing for a couple
So
to.
a dwelling would be, it has to have a bathroom, a kitchen.
I mean, you're the one who just told me it's a dwelling, using your words,
Well,
so
I'm
what is
just-
it? Like, I'm
just
trying to
saying
figure out what is
there's
it?
a bunch of crossovers.
Yeah, we may not.
What is this?
We may not solve this tonight, but it is definitely something, you know, before we get to a decision, that we need to resolve what is the bus. And because, I'm not sure, just because the state's gonna change the law about permanent residence, that it applies in this case. I'm not saying it doesn't, not saying that you can't use it, but I think we really, to Ann's point, we really need a clear what you're gonna do with it and what that then is.
I mean, I think under number 156, recreational vehicle, I mean, the bus is essentially a recreational vehicle at this point. It's not as advanced as many recreational vehicles, but essentially it is that.
Then the question is, is it allowed to rent out a recreational vehicle on somebody's property?
And does it meet the definition of recreational vehicle under state law?
I mean, looking at this definition, it is currently, does not have a current registration sticker, but it could be registered. But it's also, not used for human habitation more than 6 months in a 12-month period, so it's not used more than 6 months. So
I get you, but that's different than something that's parked and you're renting it, in my mind. I guess what I'm saying, what I'm thinking is as the time goes, and we've kind of got another meeting anyway, these are some of the key questions that you need to be able to answer when next we see you. And then is it?
Yeah, I mean, I'd love to, love to answer them, and also I'm looking for guidance from you all.
Yeah.
Because,
I think we need to.
Yeah.
Yeah.
No, I
I mean, I've studied the code, and I came to you with, these uses, and also talking.
I think also, can I say one more other thing? The other part of it, the yurt and the barn, I think number 44 does fit, but I also think 16 also fits. You mentioned in the proposal, cultural facility and community building.
16 is,
Sorry, am I looking at the wrong one? Hold on, I've got different, hold on, sorry. Got an old version here. Do we not have it anymore?
what?
Institutional or cultural facilities.
That's 21 now.
21,
Yeah,
thank
it's-
you.
it's what you referenced.
Oh, did you already?
Yeah, that's what,
Yeah. Okay, yeah, so that one. Oh, I see, right, clubs, number 11 or number 21, I apologize, yeah.
So forgot to circle back when we went down a rabbit hole, but I think when you are trying to separate the yurt from the bus, I'm not saying it's not right, but the argument they're making is it's all one use. So you don't need to know what the bus is by itself, because when coupled with the yurt, it's all one use.
Yeah.
I'm not saying we buy that. I'm
Right,
saying
I'm just
like,
saying
that
that it
is, I
seems like a
think-
different, way, people are staying over in the bus, sleeping, Airbnb, that's not happening elsewhere. I feel like that is a big,
Well, that could be a decision we make, which is it's not.
maybe it's not, I
To
don't
say,
know.
that the bus is not, because the question you have to answer is, do you plan to use it for non-educational purposes? If somebody wants to come to Maine in the summer and they want to walk Bradbury or go shopping at LL Beans, are they allowed to rent it?
Well, they are, and we also always provide education to them as well. So we're always sharing about our organic practices, we're sharing about what we do, and we'll be sharing about our solar panels and renewable energy. So, are they all taking a workshop? No, not necessarily. And yet at the same time, what a lot of farms are doing now, including us, using these types of programs to really, add to and help, ultimately people coming in understanding what organic agriculture in Maine looks like. That's an education. It builds, them to have a greater appreciation for what it takes to have a working farm. And, they're often gonna then go down to Old Crow Ranch and buy some meat from them. They're gonna, go to Bradbury, enjoy, Bradbury or the Durham River Park. So I think it is educational for them to stay at the farm. We're not going to require everyone to participate in a workshop, though.
But there's also weddings and other parties too as well, right, with that
So it's an
whole thing.
accessory use.
Yeah. I think we need to sort it out amongst ourselves and
Accessory apartment.
and do that. And how is that
an
bus defined and is it
accessory
appropriate use?
Exactly.
Right, so if it's an accessory use to the educational, or even honestly to the barn, couldn't be to the barn, because that's not permitted in that zone. So if it's the bus is an accessory use to the educational yurt, then it has the same conditional use approval as the yurt.
Yeah.
Got it.
I'll be honest, if it's a standalone building, I think it's a bed and breakfast under our definition.
So you're hearing our comments, and I'm, we're talking about educational uses till you said we're not gonna make them. And then, those are our comments now, that doesn't mean we've decided, okay? So we're telling you, you know, what we're thinking about on this, so you'll get a chance to respond to our comments down the road. Alan, did you have any?
I don't.
Okay.
Can I just offer a couple of observations that might help clarify the confusion? It seems to me there's 2 points of confusion. First is, what is the relationship of the proposal to the existing operations? And I agree with Ann that you don't need to consider the existing operations because they're either in violation or they're not. They're just asking for a conditional use approval for what they are proposing. So you don't need to worry about what's going on right now. Then secondly, in terms of these uses, I don't think there's anything that they are proposing that couldn't fit within something here, because 31 says, other commercial services not otherwise listed. If the bus, you're not sure exactly what it is it a campsite, is it a rental, what is it? It can be approved as a conditional use as long as it meets all the conditional use criteria. So I understand that you want clarity, because what are the impacts of having it be Airbnb or not? So as they come back and they process, you make a decision, you can put conditions of approval on this. If you're not comfortable with the impacts of an Airbnb available to the general public, you could approve its use for accessory to their operations. So again, I'm not trying to solve it, I'm just trying to suggest ways that it could be processed to come to a conclusion. So I think anything that they're proposing could be approved as a conditional use, and you can put restrictions on whatever parts of it you think need to
If
be
we feel it's appropriate.
in order to meet the conditional use criteria.
Yeah, except 31 doesn't help the bus, because it's in resource protection.
Yeah.
Right, but a couple of them are. And we could only have one use, right?
No, you
No.
can have multiple uses on a property.
Yep.
And it would take the more strict one. Or no?
All of them have to meet the conditional use criteria.
Are you talking about which standards apply if the parcel is in 2 different zones?
Yeah, no, 2 different uses. Some uses you can't be in RP, some uses you can.
You look at them separately. So like the barn is not in the RP.
Right, so it would be based on the
Yeah.
definition between the RP on
Yeah.
that parcel, yeah.
So, I mean, like, what's weird about this is, right, if the barn is being used for a club, are we saying nothing outside of the barn is ever gonna be used for that club? Right, so like a wedding in the barn is never gonna spill over into the gardens in the RP zone, I don't know. Cause that's a use, it's not the structure we're approving, it's the use.
Use, exactly. Or they put up a tent, yeah, just throwing things out that we need to look at, if it's a tent versus, or whatever it may be, the barn.
Yeah, right, they couldn't put up a tent for the wedding in the RP zone.
Okay, I think we've given you something to think about, and then the public may add to that at the next meeting, so.
So, I'm leaving a little bit confused, and I'm not a developer, I'm a farmer and educator. So, I just don't know I guess I'm not clear, I know there's gonna be a site visit, then we're gonna have a public hearing, but do we change things in this proposal to give back to you? I mean, because right now, I'm not clear on, like, I have a lot of speculation or ideas, but I'm just not clear kind of.
Well, and we may probably still use some information, but you've heard some comments, for instance, on the bus, in defining what the bus seems to be one of the big topics, what the bus is going to be about. But the use does cover the whole thing. So, are you gonna hold your meeting strictly in the barn, not in the resource protection area? Those kinds of things, I think, are in your court, to say, we will limit it to the non-resource protection area or whatever it may be. And then I think as we go into the next month or prior, kind of look towards the planner to give us some, kind of what you discussed there, and say, these are possible okay uses here, or these are the confusion with it. Because I think you've kind of heard our concerns.
I think also it would be more straightforward, for instance, if the bus was always coupled with like a retreat, like you're always part of a workshop, and then it would be very strictly, it falls under 44, which falls under conditional use. But since it could just be someone who's like learning through osmosis, but also is traveling to Freeport for shopping, then that seems a little more wishy-washy if it falls under 44 for an educational purpose. And that just seems like more like a rental dwelling than an actual educational facility.
Okay.
Could the bus be moved out of RP?
Yeah, it could be moved, yeah, it could be moved as well.
That would also probably make everything a lot simpler.
I mean, if we required everyone to do like a 10-minute educational workshop with us that stays on the bus, would that, I mean,
Seriously.
I'm just saying though, I mean, because, you know, one,
In my mind, it's the primary use
Yeah.
of why they're renting that space.
No
The
one-
primary use is to go to LL Bean, and I recognize that's part of the great outdoors, but, you know, the primary use is because they're, but I don't know if we haven't sorted out attending one, but their primary use is for a wellness retreat or wellness classes, and you're gonna give a multi-day thing, then that's the primary use for the people who are staying there. I guess is what I think Tyler said better than I did, which is define the primary use and let us know.
okay, I mean, yeah, just wanted to ask that question, because I mean, number 44 does not have a definition, so I don't, you know, it's kind of up to interpretation.
Sure.
I mean, as it says, you know, major interpretation. is
And that's
also-
one of the challenges, the
Yeah.
good things and bad things about conforming uses, so.
Yeah.
And any questions you got after this, I had to get with Mr. Thabarge, and he will try to help explain what I was saying here tonight.
Throw him under the bus.
Yeah.
I mean, besides, I think the confusion of all the uses, like what it is, what it's not, I'm really concerned about parking. So
That was another thing.
I want to know more about parking and what the plan for parking is.
Maybe that field, I've been to your place behind where the,
Sidewalk might help with that.
Yeah, we have plenty of parking.
in the field where you guys usually have the sales, the, whatever we call it, the setup of all the tents,
Yeah.
right back there.
Well, it's not shown on your site.
Well, yeah, so what's.
Right, you have
the
a very
site plan is-
small parking
Yeah.
area on your site.
And I think to her point is what we usually get is a rectangle, square, whatever, 20, lines for 20 parking spaces that,
Yeah.
meet the code for, was it 9 by 10 or 10 by whatever it is, number, so that we know that you can get 20, if your limit's gonna be 20, if you're gonna bus them from somewhere, and you can't fit 20, then we'll know that. Because I would think the neighbors would be concerned about an overflow, out onto Bowie Hill Road.
Yeah, yeah, I mean, during our tree farm season, yeah, we've had what is shown on the map there, and so that's kind of the standard parking, and then we do have an overflow for just those weekends for
Sure.
agricultural purposes.
Just kind of draw it out that we know you can get 20, if 20 is what you're saying, or 30 or 5 or whatever it is, just draw it out as an.
So if I take the map that exists and add lines to it to show.
If it's scaled, sure. I think that'd be fine. And you're walking around, that's a good question, after you've sketched it up, to run it past Mr. Thabarge,
And sidewalk might help too.
and the site visit would also help. I do have another concern, though, other than the uses, which is the hours of operation. That is, I know you've been successful with the daytime stuff, but now you're talking about stuff that could go to 10 o'clock, and that seems late in that neighborhood.
I think it was 9.
Be quite
No, I said 9 and
Still.
occasionally 10,
Yeah.
Okay.
Occasional time.
a few times a year at most.
for weddings and stuff like that.
And we would tell the neighbors, we would let them know, hey, there's a wedding this coming weekend. You
Yeah,
know,
but
they
we
wouldn't
need
be
to
shocked.
draw a line under it that, from here, from whatever it is, because if it goes to 11, then, the code enforcement officer shows up on Monday and said, I got a complaint about 11 o'clock, and so to shut it down at whatever time, we agreed to. But that isn't my
Yeah.
concern, it seems to me 10 is late. Now, it's because it seems to me the other 4 votes may disagree.
Yeah, no, I definitely understand that, and, and that's a condition of approval, we'd be fine to, make it earlier, yeah.
I like to be in bed by 10.
Yeah, I mean, we live there, so, it's,
Yeah.
we're not, definitely it's not something we're not looking to have late night parties all the time, definitely that's not what we're interested in.
Wedding, sometimes, having just married off my daughter a couple of weeks ago, and pointing to my watch at 9 o'clock, my wife would still not let me leave, so.
The other big concern I have is noise. You've got neighbors right across the street from all these uses. and the noise limits in the ordinance are really low, really low. So I wanna know how you're gonna address that.
What page is the noise ordinance?
Section 5.19.
We've thus far had productive conversations with our neighbors who have been supportive of our mission, and also about existing noise and things also running a Christmas tree farm, you're running a chainsaw, you're making noise.
I think that's different though than 9 or 10 o'clock. And I think that would be one of the big concerns.
Bands playing in a show and all of it.
Yep.
Yeah.
Ann's got an excellent point there.
And I will comment about that. I've had some complaints about noise already, and that is an extremely difficult item to enforce. Virtually impossible, even from our town attorney says, no, don't go there.
I hear what you're saying, but there is a rule, and you need to follow it.
And we need to at least take it into consideration.
Yeah,
And at least, right, it needs to at least pass a straight face test that you can pass it.
Yeah,
I'm not saying that if it goes over on occasion, you're getting slapped with the violation, but we need to, in good conscience, at least be able to say, there's a good chance that they can comply with it.
Yeah, and as I said, so I have a background, I ran 2 different spaces in Portland with, and we had noise complaints, we dealt with them, we worked through them and, worked to resolve and have no noise complaints. So,
Yeah, and we're just gonna.
I think it's possible, I know it's an issue, and it's definitely something where, being good neighbors is really important to us.
Yeah, no, and I appreciate that, but we need to draw a line that says this is it.
Yeah.
And if you see there's something.
To clarify, it wasn't noise complaints about these people, it was other.
I'm not saying it was.
4th of July.
Big one.
Oh, yeah.
We heard that, yeah.
Okay, any other, we want to make sure you cover those, so we're going to come back and ask you what hours are you proposing, and we'll vote on whether those, are acceptable or not, given, because it is the character of the neighborhood that matters. And so one of the things that I at least have to be convinced with is what you want to do fits the character of the neighborhood.
Okay, so address, just so I can summarize here, add some lines to our parking map, you look at it when we have the.
This is, you can fit whatever number you think you're going to need.
Yeah, and then, we do, in our proposal right now, we do talk about 9 PM with occasional events going to 10.
I don't know what it's, if you could ask what I think is a good time, I don't know at this point,
Okay.
so.
Okay,
Well,
I just was seeing if there's any additional pieces that would be helpful, like getting a noise decibel meter or something like that, that would be helpful to addressing any noise issues. I just want to make sure as we come back, we use everyone's time effectively and be able to address any issues.
Noise is sometimes covered in, I don't know what they are, but there's graphs that'll say, a polka band, inside a building from this distance these are gonna be the decibels.
Where's the polka band?
It's in there, I'm sure it's in there somewhere.
5 points.
5.19 polka band.
Okay, good, thanks.
It's not ours, but there are,
We did not address the polka band.
there are
Everyone allowed
professionals.
abandoned.
I'm sorry, I'm taking up time with jokes. Is there anything else we need to highlight to these folks
Yeah.
going forward? I think we're good. We'll see you next month.
Okay, so we'll welcome you all with the site visit.
5 PM on the 7th.
Yep.
5 PM on the
All right.
7th, and just to clarify, so there will be a public hearing next time,
Yes.
and so we can invite folks to come and share their
Yes,
perspectives.
we notify them. Do we make sure we notify them?
We'll be posting.
Yeah, there'll be a posting, and I'm sure you'll see it on All Things Durham and Durham newsletter and other things. So yes, the more you can do now with your neighbors, the easier the process will be for you.
Right.
It sounds like you've already
Thank you
started.
for your neighbors.
And I apologize for just running so late, but thank you.
Thank
Can
you.
I make a request?
In the same room here?
If we're,
With this amount of
yes.
It'll be the same
Yep.
place.
If we're doing agenda items that will not have public comment versus those that will, can we put that on the agenda? Right?
Yes.
This item will not have public comment tonight. This item will have public comment tonight. I think that would help.
Yeah.
Yeah, no, that's a good point. George, please.
Mhm.
Thank you. That is an excellent point.
Great.
All right.
Thanks, everybody.
Thanks.
Thank you for your patience.
I'll still make my 10 o'clock bedtime, so.
Yeah.
The last thing on the agenda, thank you all, but there's one more thing on the agenda. That will hopefully not take long, but it is, we're working on these changes to the codes. And George put together some information on affordable housing. So just a brief recap. The Historical Commission is working on any changes they want to do. The Conservation Commission is working on changes they want to do. It is their responsibility to go through the public discussion period, and it is ours to hold the public, we can, the ones that have to hold a public hearing. So the goal would be to hold public hearings in late January, February of next year to be ready for the April meeting, so. And
But also doing some workshops or informational meetings this fall, starting probably September with organizing informational
Yep,
meetings.
and
and
those
doing them
two
in
commissions will
October.
do their pieces.
Yes, and you probably want to do the affordable housing on a separate track, because each one of these items could attract quite a gathering.
And I guess briefly, George, and if everybody's had a chance, we don't need a lot, because I think people have either had a chance to read it or it's pretty self-explanatory. The two things that are in the planning board's bailiwick are the state, as Alan referred to, the state changed the law, making mandatory houses going on properties. So he has taken a cut at changing our ordinance to match that law, to meet the standards of that. And so,
Did you send that out, George?
It's in your packet.
Oh, for tonight?
Yep.
Yeah.
So
Didn't
basically,
scroll
the
far
new
enough.
law that goes into effect next July says that all single-family zones have to allow multiple dwellings on the lot up to 3. I took a stab at it to make the least impact possible. And so what I thought was, right now you allow duplexes, but you have to have 2.5 acres instead of 2 acres. You can't do that anymore. If you allow a single family on 2 acres, you have to allow a duplex on 2 acres. Secondly, currently you allow a single family to have an accessory dwelling. It's limited in size. They say you have to allow up to 3 units, not just those 2. So to try to keep it as simple as possible with the least change possible, the draft language that I put together as a starting place says, instead of only allowing 1 accessory dwelling unit, you would be allowed to have 2. If you had 2 acres.
2 acres.
Okay? 2 acres, or you could put in a duplex with 1 accessory dwelling unit. Total of 3, no matter what you do. That would be the least amount of change, because right now you could do a duplex, but you can't have an accessory apartment. All this would do is just say you can have an accessory apartment with a duplex. Secondly, currently the ordinance allows you to have 1 accessory apartment. You would now be able to have 2. That may or may not fly with the language of the state, which is very confusing and not clear. MMA is even struggling with how to figure out, what did the legislature actually approve. So I think that would have the least change, but might have a chance of flying and passing what the new legal requirements.
Well, and I don't think they can always say no, but I mean, the law is gonna change, so either the state's gonna impose something. And my question or concern is that we use the term accessory apartment, but it could be a house. If it's the
Well,
third
no,
second.
I'm proposing to try to keep it from flying out.
According to the state,
According to the state, they say can be, this combination, that combination, every combination. And I'm suggesting that the town, just as a starting place, to have the least impact, the least change, just allow 2 accessory dwelling units on a single family and allow 1 accessory unit with a duplex for a total of 3. That's the magic number for
You're
the
using
state.
dwelling unit.
Accessory unit or
but that's-
dwelling unit,
Yes.
not.
That's for lots that already have.
Yeah, but we don't even know why. It doesn't make any sense the way they wrote it, other than I think what they were striking at was the issue of, it says it has to be, it doesn't nullify the need to get subdivision approvals. So if you have one existing and you add two, that would trigger subdivision. So I think that's what they were striking at.
But why would we allow more dwelling units than we have to?
I don't think we are.
I don't think we are.
Right, so the law, and this is the first time I'm reading the final piece, and it would be really interesting to see if MMA has draft language. A lot of
I
times
was
they'll
hoping that
do
they would,
model
they said they
language.
don't, because it's so new.
Right, but just reading the summary, I haven't gone and looked at the statute. Right, it says you have to allow them to add one dwelling unit to a lot that has an existing dwelling unit. So that's a max of 2 that you have to allow them, not 3. If you're starting from scratch
Yeah.
with a blank slate, you have to add 3. You have to allow them to add 3. So I'm not sure why we would be, and again, I've looked at this for 30 seconds. I'm not sure why we would say everybody gets 3. So my house has a dwelling. It has
One
has a
question would
house.
be, let's just say, what happens the next year after they do it? Are they now prohibited from adding one?
No, you grandfather those developed lots. I mean, it's like a negative grandfathering, I guess. But you basically say any lot that has a dwelling as of whenever, 2023, can add up to 1 additional dwelling unit. Any lot that does not have a dwelling unit as of whatever date, 2023, can add 3 new ones. But they'll need to go through subdivision.
That's vacant lots, right?
Yeah.
So
let's
vacant
take-
lot, you can do 3. If you got an existing house, you can only do 2.
Two.
Yeah.
So let's take a look
That's
at,
what it looks like.
if that's the way it is, that's, I hate to, you know, if it's better for the town being happier, I guess, but,
And I mean, I need to go look at the underlying statute, but it looks like we may be able to limit the new one on an existing. I don't know. I gotta look at this more.
Okay.
I would like this to be as narrow as it can while still complying with state law.
yeah, I think that is our intent. So what the plan, then the other one that we haven't, I don't think was in the thing is,
Oh, maybe I had that
Back
backwards.
lots and roads.
well, I'm still not sure who the town say the back lots, but explain it, George, you'll do better than I did.
Is that what you're talking about?
Yes, the road issue.
Yeah, we just need to add some clarifying language that you have to go to town meeting and get a road accepted.
That's it.
Well, I thought the last one got tanked by a certain individual who wanted to make sure it didn't apply to existing roads.
The chairman, or whatever his title, chairman of the select board asked for that language George just
During
mentioned.
the town meeting, somebody raised a question of, and concern for, the ordinance doesn't say whether the town accepts roads or not. So-
Yeah, but it died the last time because a particular developer in town was not convinced that his existing road would not have to be brought up to the new road standards. So I think if we can add a line along those lines, that would be, I think, to our benefit.
Yeah. So part of why you wanted it on the agenda was not to necessarily talk about these details, but to talk about a public process.
Yeah.
So I did talk to Devin tonight about, there was a plan to get Eureka fully up, internet accessible, to be able to do all our meetings over there where there's more room for people. That has been on hold because it's so confusing how to do it. But I did talk to Devin about an interim plan, either at the fire station, which has wireless, or over at Eureka, to have IT basically video it with a webcam on a computer. And if it's over at the fire station, then they can stream it on YouTube. If it's over at Eureka, which you don't have wireless, you could record it and then broadcast it later.
I think that's what we've done, except Heather did the recording.
Yeah, but we know.
No, but I mean, I think,
Yeah.
I like the Eureka.
But getting IT to set up something
Yeah.
that will be effective and work.
So the goal would be to look at the language at the look at the language for house count and roads. And then I think we're pretty close to being able to go to the town and have an informational meeting in October, November, and get it out there. We're not as maybe controversial. Nobody's gonna want the idea of adding houses, but there's not much they can do about it. And then, so late October, November, we hold a public comment meeting, and then we're ready to go on the two topics we've got and, for a public hearing, and then we can even do it earlier, I guess. And then, but sort of plan on January, February, we're gonna have a couple of public hearings that we gotta run. That was it, and I know it's late, I appreciate the extra hour of everybody's time. And George, if you could help us with or help me at least with understanding what they're asking for. I guess what maybe I can break it out, but say, okay,
Who's asking for?
I'm sorry, back to the celebration.
We need to figure out the use. I feel like that's,
Yeah.
that's in we have to
Yeah.
do that.
But I mean, that's what I'm talking.
Happened last time.
I felt like the big issue last time was the road. Remember the access
They were gonna go across
road?
the stream, weren't they?
Yeah.
That's
I'll,
what sticks
I'll
in my
work with
mind.
Alan to see if we can try to sort that
Okay.
out a little bit.
Yeah, I think that would be helpful.
Out of resource protection too.
Yeah, I
It would
think
be a little bit similar.
I think so, yeah. I
Yeah.
think that would.
Just this,
I struggle with the bus. I mean, I really do, because I don't think.
Struggle bus. Sorry.
All right, good. So, the 7th, right? September 7th?
September 7th at 5 PM at
Right.
Celebration Farm.
Okay.
We have a motion to adjourn.
Can I make that motion?
Second.
All in favor? 5-0. Thank you.